Nathaniel's getting Jeffrey Jones. Nathaniel's getting Jeffrey Jones.
He is going to get Jeffrey Jones.
Okay.
Or no, my apologies. Jeffrey Jones, I believe, is going to be on Zoom. He was going to get David Cheney for the forensic.
Oh, okay.
And when I say Zoom,
Ma'am, are you Teresa Badgley?
Yes, I am.
All right, you're in the right place, Miss Badgley. Are we ready to go on that?
We are, Your Honor.
All right, let's go ahead and call that case. All right, we're on the record in docket 22-03350. That is people of the state of Michigan versus Teresa Badgley. For the parties, this is set for a probable cause conference today. For the parties, please introduce themselves for the record.
Good morning, Your Honor. Melanie Smith, Assistant Prosecuting Attorney here on behalf of the people.
Thank you, Your Honor. Dale Coltrader here on behalf of Ms. Badge and also on behalf of public defender's office.
All right, and ma'am, you are Teresa Badgley,
Yes, I am.
and you can hear me all right, Miss Badgley?
Yes, I can.
All right, thank you. This is the time set for a probable cause conference. Ms. Smith, how are we proceeding?
Today, Your Honor, I think we're just going to leave this set for a preliminary examination. Mr. Coltrider was not appointed on this matter until quite recently, and so he's not had a chance to review the plea offer that's been made with his client. For the record, that offer is for the defendant to plead guilty to count 2, which is the misdemeanor receiving and concealing with restitution, and in exchange, the felony would be dismissed.
Is that your understanding, Mr. Colrider?
It is, Your Honor, and I would agree that we would leave this on until next week so that we could negotiate a little further and I can talk to my client a little more.
All right. Ms. Badgley, you understand that this is set for preliminary examination next week on January 6, 2023 at 8:30. The parties are leaving the preliminary examination on as scheduled and negotiations are to continue and there is an offer open. Do you understand that, ma'am?
Yes, I do, Your Honor.
All right, thank you. Ms. Smith, anything else for the record in docket 22-03350?
Nothing from the people, Your Honor.
Anything, Mr. Colrider?
No, just, Your Honor, my client is in compliance with pretrial service.
Okay, thank you. Ms. Badgley, please keep in contact with your attorney, Dale Coltrider, and you'll be back in front of, I believe it's myself, on January 6, 2023 at 8:30. Okay, ma'am?
Yes, sir.
All right, so I've been told that you, there's an outstanding order to get your fingerprints done. You can probably take care of that next week, I would think.
We'll make sure that's done.
All right, thank you. You're all set, Ms. Badgley.
Thank you.
You're free to leave the Zoom courtroom.
Thank you.
Leon Cheney,
Yes, Your Honor.
or you let me know. You let me know what you're ready to go on.
You got Mr. Drain right here. Your
Okay.
Honor. We just want to do a timeline.
Oh, this is Mr. Drain. Okay.
All right. No. So, Mr. Drain? All right, we're on the record in docket 22-01717. People of the state of Michigan versus Michael Drain. Will the parties please introduce themselves for the record?
Good morning, Your Honor. Melanie Smith, Assistant Prosecuting Attorney on behalf of the people, and standing in today for APA Del Vero.
Good morning, Your Honor. Jacob Saris, IV, Assistant Public Defender here on behalf of Mr. Drain. He's present on council table. He's staying in my right.
All right, thank you. And sir, you are Michael Drain?
Yes, Your Honor.
Okay. Ms. Smith, this is the time set for a probable cause conference. How are we proceeding?
I believe the defense has a request for Your Honor.
Okay,
Thank you, Your Honor. At this time, Mr. Drain is going to voluntarily waive his timeline, and the defense is going to be requesting an adjournment here. This case is quite complicated. We're in the process of receiving quite a bit of discovery. I got the case at the end of last week, and due to court closures and everything else, we will not have sufficient time to prepare for the preliminary examination. Further, Mr. Drain's up in Saginaw County at this time, so we'll need to make sure that the writs are properly sent out. So I will be requesting an adjournment. It's my understanding that Ms. Del Vero won't be available on January 12th or 13th. I'm not available on January 20th because I have a trial scheduled.
okay.
And the people have no objection to the adjournment. We do understand that there's quite a bit of material to uncover here. The victim in this matter did testify in a probation violation hearing in Saginaw County. That transcript has been obtained, but I understand that there's more time that's needed to review all
All
of that.
right, so once I take the waiver of the 21-day rule, we'll make sure that we get a date outside that's that works for everybody. Mr. Drain, you heard the lawyers talk here.
Yes, Your
You
Honor.
understand you have a right to a preliminary examination within 21 days of your date of arraignment.
Yes, Your Honor.
And that preliminary examination is a probable cause hearing in which the people of the state of Michigan would have to prove by probable cause evidence that a crime has been committed and the identity of the person who committed that crime in this file. Do you understand that?
Yes, Your Honor.
If you waive your right to a preliminary examination within 21 days, you will not be waiving your right to a preliminary examination. You'll only be waiving your right to a preliminary examination within that time period. Do you understand that, sir?
Yes, I
Is it
do.
your intent today to waive your right to a prelim within 21 days?
Yes, Your Honor.
All right. I find the waiver of the 21-day rule to be knowing, voluntarily, and accurately made. And we will set this, how far out do you, a date, Mr. Sarks? Are you-
Preferably after the 20th, Your Honor.
Okay, so we'll set this for prelim. Do you need an additional PCC?
Probably not.
Okay.
I have good communication with Ms. Del Vero. If we need to do anything outside of just run the exam,
All right,
I'll have this conversation with her.
so preliminary examination after January 20th. Okay. So we set it on January 26th at 8:30. So, Mr. Drain, we'll set it for January 26th at 8:30. Please keep in contact as best you are able to do with Mr. Sarts from the Public Defender's Office. Anything else for the record, Ms. Smith?
Nothing from the people. Thank
Anything,
you.
Mr. Sarts?
Nothing further, Your Honor. Thank
All
you.
right, Mr. Drain, we'll see you on the 26th, okay?
Thank you, Your Honor.
Whenever the court is ready, we are ready on the matter of Jonathan Lee.
Jonathan Lee.
It's going to be a waiver of exam.
All right, we're on the record in docket 22-03032. That's people of the state of Michigan versus Jonathan Lee. Will the parties please introduce themselves for the record?
Thank you. Good morning, Your Honor. Melanie Smith, Assistant Prosecuting Attorney, here on behalf of the people.
Thank you, Honor. Dale Coltrader, here on behalf of Mr. Lee, who's standing immediately to my right. Here also on behalf of public defender.
All right, and sir, you are Jonathan Lee?
Yes, Your Honor.
All right. This is the time set for a preliminary examination. Ms. Smith, how are we proceeding?
Today, Your Honor, the people and the defendant are prepared to waive their right to a preliminary examination here in the district court. That's an unconditional waiver, understanding that there's not an offer here at the district court, and all plea negotiations should continue in the circuit court. We ask that you bind this matter over as charged.
Is that your understanding, Mr. Coltrider?
That'd be a correct statement, Your Honor. It would be further negotiations at circuit court.
All right, may I inquire of your client of his waiver of his preliminary examination?
You may, Your Honor.
All right. Mr. Lee, you understand you have the right to a preliminary examination today.
Yes, Your Honor.
And that preliminary examination is a probable cause hearing in which the people of the state of Michigan have to prove by probable cause evidence that a crime has been committed and the identity of the person who committed the crime in this file. Do you understand that?
Yes, Your Honor.
You, of course, were represented by Dale Coltrider from the Public Defender's Office, and he would be present to cross-examine any witnesses and contest any charges brought against you. Do you understand that?
Yes.
It's my understanding your wish today is to waive your right to preliminary examination. Your time will be done in district court. It'll go to circuit court, which is a different court, and that's the trial court, and your time will be finished in district court. You'll be waiving your right to preliminary examination. My understanding is that negotiations are to continue in circuit court.
Yes,
Is
Your
that your understanding?
Yes, Your Honor.
All right. So is it your wish today to waive your right to preliminary examination and be done in district court?
Yes, Your Honor.
All right. I find that the preliminary examination waiver to be freely, understandingly, and voluntarily made. The people also waive their right to preliminary examination. The next date will come from your lawyer, most likely in circuit court. So keep in contact with your attorney, Dale Coltrider. He'll provide you with the next circuit court date to appear in circuit court. But your time in district court is now finished. All right, sir? All right. Anything else for the record, Ms. Smith?
No,
In
Your Honor.
docket 22-03032.
No, thank you.
Mr. Coltrider?
No, Your Honor.
All right, thank you. You're all set. You'll be in circuit court next, Mr. Lee, okay?
Yes.
Thank you. Oh, and Mr. Coltrider, yes, you got to sign the binder. So let's, Nathaniel's not here, so,
I can approach you.
yeah. Yeah, you'll need, Mr. Lee, you'll have to sign the bind overs, just that you waived today.
Your Honor, I believe for Mr. Ray, we are just leaving the matter set for a preliminary examination next week.
Okay, I don't have him, I don't have that file.
I think Ms. Holden had removed it from the docket with the understanding that the PCC had
Right.
been completed via email.
So let me let him know that, so he's. So the prelims left on for next week. So, Mr. Ray, Keyshawn Ray, can you hear me?
Yes, sir.
It's my understanding that your preliminary examination has been left on for next week. So you should be in contact with your public defender in that regard, but the case is left on for preliminary examination for next week. At this, it'll be, do we have a date or a time?
It's the 6th. I don't have a time. 6th at 8:30.
So it'll be January 6th at 8:30. All right, sir?
Yes. Yes, sir.
Okay, so you're all set. You're all set in this courtroom today, all right?
All right. Thank you, sir.
I'll be in touch.
Thank
Mr.
you.
Lee. Mr. Ray, I'm sorry.
Thank you, Mr. Co-writer.
Your Honor, we are all set to address the case of Franklin Dumont.
Okay,
It's going to be a request for adjournment.
it's Mr. Dumont. All right, we're on the record in docket 22-03439. That is People of the State of Michigan versus Franklin E. Dumont. Will the parties please introduce themselves for the record?
Good morning, Your Honor. Assistant Prosecuting Attorney Melanie Smith on behalf of the people.
Erin Robinson, Assistant Public Defender for Mr. Dumont, and standing to my right.
And sir, you are Franklin Dumont?
Yes, Your Honor.
Okay, this is the time set for a preliminary examination today. Ms. Smith, how are we proceeding?
Thank you, Your Honor. From the people's perspective, I believe from the defense perspective, the goal here is to get this defendant into treatment. We think the best modality for treatment would be the 54B drug court. We just need some additional time to get the screening intake process started to make sure he's eligible. And then ultimately, we believe that this would be a transfer over to the 54B district court. But we'd request an adjournment of maybe 2 to 3 weeks to allow that to get done.
All right, and has the defendant waived his right to a prelim within the 21-day period?
I
No,
believe-
Your Honor, he has to do that today,
Okay,
but he
he's
is
gonna
willing
do
to do that.
And that's your understanding, Ms. Robinson, he's going to waive his right to a prelim within 21 days and seek screening in drug court for the adjournment.
Yes, Your Honor, and we've already sought out the screening. I think we're just waiting for the person who does that to come back from vacation.
Okay. Mr. Dumont, that's your understanding?
Yes, Your
All
Honor.
right, you've heard the lawyers talk. So you know you have a right to a preliminary examination within 21 days of your date of arraignment. Preliminary examination is a probable cause hearing that the people of the state of Michigan would have to prove by probable cause evidence that a crime has been committed and the identity of the person who committed the crime in this file. Do you understand that, sir?
Yes, Your
You're
Honor.
of course represented by Public Defender Erin Robinson, and she would be present to cross-examine any witnesses and contest any charges brought against you. Do you understand that?
Yes, Your
It's
Honor.
my understanding that you wish to waive your right only to a prelim within that 21-day period. You wouldn't be waiving your right to a preliminary examination only within the 21-day period so that you can seek an adjournment in this to have you screened for another court. Is that your understanding?
Yes, Your
Is
Honor.
it your intent today to waive your right to a preliminary examination within 21 days?
Yes.
All right. I find the waiver of the 21-day rule to be knowing, voluntarily, and accurately made. How far do we need this set out? This
Let's
sounds
do
like
3 weeks to be safe.
3 weeks. All right, so we'll set this out for preliminary examination, understanding the defendant is being screened and has already been screened, so it's just acceptance into that court for
January 20th at 8:30.
January 20th at 8:30. So, Mr. Dumont, please keep in contact with your lawyer, Aaron Robinson. You're scheduled to be back in this court January 20th at 8:30, and then we'll see the screening process for the drug court. Okay, sir?
Yes, Your Honor.
Anything else for the record, Ms. Smith, on docket 22-03439?
No, Your Honor, thank you.
Anything, Ms. Robinson?
No, Your Honor, thank you.
All right, thank you. That's all for the record. We'll see you on the 20th, 26th or 20th? 20th. We'll see you on the 20th, Mr. Dumont.
And the people are ready on the matter of Tyrese Bell, to be a misdemeanor plea.
All right. So we're on the record in docket 22-03472. That's people of the state of Michigan versus Tyrese Bell or Tyrese Bell. Will the parties please introduce themselves for the record?
Good morning, Your Honor. Melanie Smith, Assistant Prosecuting Attorney here on behalf of the people.
Aaron Robinson, Assistant Public Defender for Mr. Bell, who's standing to my right.
And sir, you are Tyrese Bell?
Yes, sir.
All right. This is the time set for a preliminary examination in the file. Ms. Smith, how are we proceeding today?
Thank you. It's my understanding that the defendant intends to enter a guilty plea today. That would be to an amended count 1 of attempt, police officer resisting and obstructing. Moving that to an attempt makes it a 1-year misdemeanor, punishable by 1 year and or $1,000. Count 2 would be dismissed. Pursuant to Killebrew, the people and the defense have reached an agreement that the defendant would serve no additional upfront jail at the time of sentencing, understanding that there would be a term of probation at the court's discretion.
All right. So just so I got the terms correctly, we're going to amend count 1 to the attempt R and O. And my understanding, correct me if I'm wrong, that would be MCL, it'd be the same MCL code 750.8181D, parent 1, parent A for the attempt.
That's correct, Your Honor.
And then that would cut everything in half, so it's a 1 year and or $1,000.
Absolutely correct, Your Honor.
So that's the amended count 1, and with that count 2, the 2 year would be dismissed, and then there's a Killebrew of no upfront jail. All right, Ms. Robinson, is that your understanding of the plea?
It is, Your Honor.
All right, thank you. May I inquire of your client of his advice and rights concerning the misdemeanor?
You may.
All right, Mr. Bell, you understand the maximum penalty for the amended count 1 attempt R and O is a 1 year and or $1,000. Do you understand that? All right. And there is Killebrew agreement of no upfront jail, but your understanding is that the ultimate penalty in this is 1 year and or $1,000.
Yes, sir.
All right. With a plea to that, the count 2 will also be dismissed. Is that your understanding?
Yes, sir.
All right. In this misdemeanor plea, you have certain trial rights that you're going to be waiving. I'm going to walk you through those. Okay. You have the following trial rights concerning this misdemeanor plea. You have the right to be tried by a jury. You have the right to be presumed innocent until proven guilty. You have the right to have the prosecutor prove beyond a reasonable doubt that you are guilty. You have the right to have witnesses against you appear at trial. You have the right to have the court order any witnesses the defendant has for your defense to appear at trial. You have the right to question any witnesses brought against you at trial. You, of course, are represented by Public Defender Aaron Robinson. She'd be present to contest any charges or cross-examine any witnesses brought against you. Do you understand that, sir? You have the right to remain silent during the trial. You have the right not to have that silence used against you. And you have the right to testify at trial if you choose to testify. Do you understand your trial rights in this matter?
Yes, sir.
All right. Are you willing to waive your right to plead guilty today so we will not have a trial?
Yes, sir.
All right. If your plea is accepted, you'll give up the claim that the plea was a result of any promises other than the plea agreement or threats and that it was not your choice to plead guilty. Do you understand that?
Yes, sir.
All right. Giving up the right to appeal means that you give up the right to appeal any trial issues. Since you won't be having a trial, you'll also be giving up any right to appeal a trial issue because you're going to plead guilty today. You understand that? Is it your intent today to waive those rights and plead guilty today? Okay, I'm going to have a raise your right hand. Do you solemnly swear or affirm to tell the truth, the whole truth, and nothing but the truth under penalty of perjury? All right. I'm going to bring your attention back to December 12th of 2022 at the location of 518 West St. Joseph, City of Lansing, Ingham County, State of Michigan. On that date, December 12th, 2022, at that West St. Joseph location in the City of Lansing, were you present on that day? All right. And tell me what you did in count 1, which makes you guilty of attempted resisting and obstructing.
Walked to my window, I didn't have a key. I shared the house with my brother, but he ain't there right now because he worked all day at Meridian Magnesium. And the officer actually thought I was trying to break into somebody's house because once he hit corner of St. Joe, he stopped and then he flicked his lights. He like, hey, stop with the police. What is you doing? I was hopping on the window. I got all the way in there once he told me to stop. That's what it resist, I believe.
All right. Did you know as a police officer when you disregarded the order to stop?
No, I didn't stop. No, I just.
No,
Okay.
he's asking if you knew it was a police officer that told you that.
Yeah.
So you knew as a police officer and you didn't stop, you continued on.
Yeah, he flicked the lights on before I even got all the way to, but he knew.
All right. So you knew that it was a Lansing police officer performing his duties and that you disregarded the order at that time. All right. Is that a yes, sir?
Yes, sir.
Okay, thank you. Ms. Smith, is any question on the factual basis?
I'm satisfied, Your Honor.
All right, Ms. Robinson?
We're satisfied.
All right. I find the factual basis to be knowing, voluntarily, accurately made. A correct factual basis for the amended count 1 of attempt R&O. Count 2, the count 2 is dismissed. Make sure I write that down. Count 2 is dismissed. And we're scheduling a little further out, but I'm going to refer this to probation. So you're to report to probation. And since you're here, why don't you do it today? All right, let's get it done today. Get all the information to report to probation today. So you'll have that. So you'll have this done before the weekend. You'll go there. You'll answer any questions, and what they'll do is they'll prepare a report for me. We'll schedule a date of sentence, and then we'll figure out. You have a Killebrew of no upfront jail. Okay, so if I don't follow that, you can withdraw your plea. But for right now, I don't see any purposes in that. Let me get the sentence, and we'll decide what we're going to do. Okay. All right. So sentencing date of March 14th at 1:30. Yeah, we're scheduling a little out there. So you set up that, go to probation and set that up today, answer any questions, and then we'll see you on the 14th, okay?
Downstairs, right?
Fifth floor.
It's the 5th floor.
Oh,
Yep, yeah, so you're right, downstairs, 1 floor down. All right. Anything else for the record, docket 22-03472, Ms. Smith?
No, Your Honor.
Anything, Ms. Robinson?
No, Your Honor.
All right, thank you. That's all for the record in that file. We do have somebody here on the tablet.
I believe that maybe Mr. Jeffrey Jones.
So, Mr. Benavides, ma'am, and Your Honor.
All right.
Sorry, Your Honor.
Now, we got to figure out what we're gonna do with Mr. Benavides. Since the order's in there, all right. So let's go ahead and call this for the record. On the record, docket 22-03368. That is people of the state of Michigan versus Sane P. Benavides. Will the parties please introduce themselves for the record?
Good morning, Your Honor. Melanie Smith, Assistant Prosecuting Attorney on behalf of the people.
Thank you, Your Honor. Dale Coulter appearing on behalf of Mr. Benavides, also on behalf of Public Defender's Office.
All right, this is the time set for a probable cause hearing. And as we looked at the docket yesterday, we saw Mr. Benavides' name on here. I'm pretty familiar with his father, okay, in this matter. And so I'm under duty to recuse myself from the case just because of the relationship that I've developed with this, with St. Paul Benavides Senior in this matter. And I think both council are aware of that now.
I've been made aware, Your Honor.
Okay.
I'm aware, Your Honor.
All right. So, so I'm going to go ahead and sign my portion of the order of disqualification just because of the relationship.
All right, I can't do anything.
I think the appearance of impropriety would be the main one because of my relationship with his father. And I will sign that and then have the chief judge sign the order of disqualification. So we'll leave. Is this being left on for preliminary examination?
At this time, yes, Your Honor.
It is, Your Honor. I was just appointed on this yesterday.
All
It's
right.
150 pages of discovery. So I just got it last night.
So we'll leave on for preliminary examination at the probable cause conference, and then we'll let you decide on the adjournment from there.
Okay, that would be great, Your Honor.
So leave on for preliminary examination. So, Mr. Benavides, we're leaving your preliminary examination on for January 6th, 2023 at 9 a.m. That'll be in front of a different judge. All right, sir?
Yes, Your Honor.
Okay. And, but it's left on for now. I do think we'll have to see what judge it goes to, and the chief judge will have to sign off on it. But it's left on for preliminary examination. Anything else on 22-03368, Ms. Smith?
Nothing from the people. Thank
Anything,
you.
Mr. Callwriter?
No, Your Honor.
All right. So please keep in contact with your attorney, Dale Callwriter, and I'll let you know what your where your prelim is going to be next week. But it is set for January 6th at 9 a.m. All right, sir?
Yes, Your Honor. I
All
have
right.
a question.
Sure.
Due to due to the incarceration I had, right, the reason why I missed court, and they were telling me the reason why I didn't get a magistrate Fillmore told me the reason why I wasn't getting bond was because of due to the fact I missed court because of the incarceration. But I have
All right.
a job, and you know, my foundation with support is there. I really wanted to get back out to work and back to my routine.
I understand your predicament. I'm going to withdraw from the case, so any bond or any look at bond will be done by a different court, and that can be brought by your lawyer, Mr. Callwriter. Okay, sir?
Yes, Your Honor.
All right, thank you. That's all for the record on that file. Thank you, Ms. Smith, and thank you, Mr. Callwriter, for your appearance. You're all set, Mr. Benavides, for today. Okay, sir?
Thank you, Your Honor.
All right.
Thank you, Your Honor. I'm gonna step out of the courtroom for a moment and just get some witnesses
All right.
together, okay? That's
Sure.
right.
And Mr. Silverthorne, you're here for Mr. Abbott today?
That's correct, for David Lee Cheney.
All right,
I'll be right back, Your
sure.
Honor.
How are you, Mr. Feigelson?
Well, Your Honor, good to see you.
Good to see you. We spent the weekend together, so.
I'm gonna go that way. Thank you.
Mr. Nickel, how are you?
Good. When I said to agent pass, right? So I said, well, agent pass.
It starts this here on Mr. Jones, I think. All right. All right, Mr. Sarts, you're here on Mr. Jones.
Correct, Your Honor. We expect the guilty plea this morning.
All right. We'll wait for him to join us. I think they're just replacing who they have on the tablet.
You know what I'm saying? Why is it not moving? Because nobody wants him there. He's causing all types of problems. And he wants to take control of everything. The guy is fucking smart and stupid at the same time. Yeah, I ain't bothered at all. Can anybody investigate this other than Agent Pat? I want to talk to, I'm done. I want to talk to a supervisor. I'm getting railroaded, and Agent Pat is not.
So, sir, you are David Cheney?
Yes, sir.
It's not fair.
All right. Give us a second. We'll call your case. We're gonna get your public defender back in the courtroom, is in another courtroom, all right?
Okay, thank you.
You're welcome.
And I know that I can't remember, I think Agent, this is some bullshit, no? No. They should have been doing it when the last time I told Agent Pat, he don't care about that shit, and everybody let them do what the fuck they want to. This is not nothing new. This is not nothing new. I ain't did nothing. I don't deserve it.
And then I'm just gonna ask you to acknowledge that I wrote them to you. And then I'll send a copy of them to the jail, so they can give you a copy. You have your right to your preliminary parole violation hearing, which is just, it's just a probable cause hearing, but these violations can happen. We have enough probable cause from statements and LPD's report. If you wish to waive your hearing.
Hold on. You said you have enough probable cause from what state? And LP. And Kathy Hicks. That's her house. But how's that probable cause towards me? Because she didn't write no statement against me.
There's enough statements for there's people willing to testify to what happened. So it's enough for probable cause. It's not saying it did or didn't happen.
No, it's only technically two people that's technically going to testify against me. That's Roy Sutton and Nathan and Hines. They together. Everybody else has been telling the PO that that has not been going on, and he's not listening to any of them. He's listening to Nathan Hines and Roy Sutton.
Was there anybody else in the house that would have been a witness to that?
Yeah, it's only Doug Jackson. Doug Jackson. He's the one that lives downstairs with me. He's the one that they come down in the sea.
Okay, so he was there about, is he on parole or no?
He's on parole.
Okay. Okay, so you want to wait your hearing?
Hey, no, I'm not waiting no more hearing. I'm done with this. This is not cool. Waiving my hearing, and it said on the paper that.
All right, so we're on the record in docket 22-02496. That is People of the State of Michigan versus David Cheney, set for competency exam today. Will the parties please introduce themselves for the record?
Thank you, Your Honor. Melanie Smith, Assistant Prosecuting Attorney here on behalf of the people.
Morning, Your Honor. Dwayne Silverthorne, on behalf of the Office of Public Defender. I'm standing in for John Abbott. I'm on behalf of David Lee Cheney, who I see is appearing on screen.
And sir, you are David Lee Cheney?
Yes, sir.
All right, and you can hear me all right, Mr. Cheney?
Yes, sir.
All right, Ms. Smith, this is the time set for a competency hearing. How are we proceeding today?
Your Honor, today we would be asking the court to adopt the recommendation from the report from the Center for Forensic Psychiatry. I've read the report. I also read the report that was written back in November for this court on a different case. Seems to me that the psychologist has done a very thorough examination, speaking to the defendant for almost 3 hours at this point. I'm not a medical expert, but it appears that she's considered the appropriate factors and based on the defendant's displays, believes that he is competent to stand trial. So I would ask that you adopt that opinion.
Mr. Silverthorne?
Yes, I have also read the 9-page report. issued by Jennifer Whitmore, PhD, from the Center for Forensic Psychiatry. I've read it in its entirety. I did skim the earlier report also, and I did previously in a limited capacity represented Mr. Cheney. And I also would second the opinion that it is a probably a more thorough report than we commonly will get in these cases. And although it notes a significant amount of mental health issues, nothing that rises to the level of preventing him be found competent to assist his attorney and to stand trial. So I will also recommend that the court adopts the report and the findings of the report.
All right, thank you. I've had the opportunity to review the competency report, which was submitted by Jennifer Whitmore. So I find that the defendant is competent to stand trial. The case shall continue to the next stage of the criminal process. I'll sign the order today. And I do not believe, because this was sent to forensic immediately, I do not believe that the defendant ever waived his 21-day rule right. Okay, so it's a misdemeanor count, so only pretrial only. So we'll set it for pretrial.
It's already set for pretrial for January 3rd.
Okay. So we'll set it for pretrial on January 3rd at 9:30, or it's already been set for pretrial on that date. Anything else for the record in docket 22-02496 from the people?
No, Your Honor, thank you.
Anything, Mr. Silverthorne, for, I know you're representing you're standing in for Mr. Abbott, but anything for the public defender?
Nothing from the public defender on behalf of the defendant. Thank you.
Thank you. All right, so Mr. Cheney, your pretrial is set for January 3rd at 9:30 in front of this court, and you'll be represented by the public defender's office. It's probably Mr. Abbott still. I'm uncertain.
Probably Mr. Abbott, but it might be the assigned public.
Okay, it might be Ms. Robinson or Ms. Sutter.
It might be.
So, but you are scheduled for January 3rd in front of this court on a pretrial on the misdemeanor. All right, sir?
All right, thank you.
All right. That's all for the record, docket 22-02496. Thank you for your appearances. You're all set, Mr. Cheney. Okay, sir?
All right, thank you.
These niggas fucking over me, man. You see this shit? You see this shit, man? The same nigga that sent me in here, the same nigga that sent me back in this bitch. I wasn't even in this. Are you fucking serious, dog? Done with this shit, man. I'm so done with this shit. They try to say he gonna let me take my ball. You're not gonna do it. So I gotta bring charge against him. I got you. I can't do anything else.
That's people of the state of Michigan versus Liana K. Mathis. Will the parties please introduce themselves for the record?
Good morning, Your Honor. Melanie Smith, Assistant Prosecuting Attorney on behalf of the people.
Erin Robinson, Assistant Public Defender for Ms. Mathis, who's standing to my right.
And ma'am, you are Liana K. Mathis? All right. This is the time set for a preliminary examination. Ms. Smith, how are we proceeding?
Your Honor, the people and the defense are both prepared to ask for an adjournment today, and defendant would waive for 21-day timeline. There is some evidence that I myself have requested that the defense obtain for us some additional investigation that they are going to do before we proceed with Ms. Mathis's case.
All right.
That's correct, Your Honor, and Ms. Mathis is willing to waive the timeline today.
All right. So that's your understanding, Ms. Robinson. May I inquire of your client of her waiver of the 21-day rule?
You may.
All right. Ms. Mathis, it's my understanding today that you're requesting an adjournment, but both sides are requesting an adjournment, and that you're willing to waive your right to a prelim within 21 days of your date of arraignment. Is that true?
Yes.
All right. You're entitled to have a preliminary examination within 21 days in which the people would have to prove by probable cause evidence that a crime was committed and the identity of the person who committed the crime in this file. Do you understand that, ma'am? You, of course, are represented by Public Defender Erin Robinson, and she would be present to contest any charges, cross-examine any witnesses brought by the state against you. Do you understand that? It's my understanding today that you wish to adjourn this matter and only waive your right to a prelim within that 21-day period. You'll still have a preliminary examination. You just won't have it within that 21-day period. Is that your understanding?
Yes, sir.
Is it your intent today to waive your right to a prelim within 21 days?
Yes.
All right. I find the waiver of the 21-day rule to be knowing, voluntarily, and accurately made. We will reset the preliminary examination.
January 20th at 9.
So it'll be January 20th at 9 a.m. And by that time, discovery from both sides should be complete, at least as to the preliminary examination. So ma'am, keep in contact with Attorney Erin Robinson. We'll be back here in this court on January 20th at 9 a.m. All right, ma'am? Anything else for the record, Ms. Smith, on docket 2203117?
No, Your Honor.
Anything, Ms. Robinson?
No, Your Honor.
All right, thank you. You're all set, Ms. Mathis. We'll see you back here on that January 20th date.
Thank you.
You're welcome.
Yes.
In the South Range.
Jeffrey Jones.
Okay.
I just don't know if they don't think they put him on just yet, if they're getting it set up.
We did a different setup for Mr. Evidently.
You know how it goes. Thank you.
That way.
Yes, ma'am.
We have a plea ready, Your Honor, on the case of Ralph McFadden.
All right. All right, we're on the record in docket 2203003. People of the state of Michigan versus Ralph McFadden. Will the parties please introduce themselves for the record?
Good morning, Your Honor. Melanie Smith, Assistant Prosecuting Attorney on behalf of the people.
Good morning, Your Honor. Assistant Public Defender Stephen Feigelson, appearing on behalf of Ralph McFadden, who's standing to my left, Your Honor.
And sir, you are Ralph McFadden?
Sure.
All right. This is the time set for a preliminary examination. Ms. Smith, how are we proceeding?
Thank you, Your Honor. Today, the defendant is prepared to enter a guilty plea to an amended count 1, which would be an attempt, fleeing, eluding, fourth degree. We're going to amend that to under the penal code versus the vehicle code. So let me
All right.
pull that PAC code for you.
So it'll be the attempt, flee, and elude.
And under the penal code, that is 750.479, capital A, parent 2.
Okay. Now, does that have an A after it?
It would have an A after it for the attempt, Your Honor. And so the penalty would go to a 1-year misdemeanor and or $250. The license suspension sanction remains the same.
All right. Perfect. Mr. Feigelson, is that your understanding of the negotiation and plea offer?
It is, Your Honor.
All right. May I inquire of your client of his misdemeanor advice of rights?
You may, Your Honor.
All right, thank you. Mr. McFadden, you understand, you've heard the lawyers talk, okay? And so the amended count that you'll be pleading to is an attempted flee and elude fourth degree under the model penal code. And the ultimate penalty for that is 1 year and or $250. Do you understand that?
Yes, Your Honor.
Okay. If your plea is accepted today, we will not have a trial of any kind. And so I'm going to walk you through some trial rights that you'll be waiving today. All right, sir? You have the right to be tried by a jury. You have the right to be presumed innocent until proven guilty. You have the right to have the prosecutor prove beyond a reasonable doubt that you are guilty. You have the right to have the witnesses against you appear at trial. You have the right to question the witnesses against you. You, of course, are represented by Public Defender Stephen Feigelson. He would be at trial, be here to cross-examine any witnesses and contest any charges brought against you. Do you understand that, sir?
Yes, Your Honor.
You have the right to have the court order any witnesses that you may have for your defense. You have the right to remain silent during the trial. You have the right not to have that silence used against you. And you have the right to testify at trial if you choose to testify. Do you understand these rights that you'll be waiving if you plead guilty today?
Yes, Your Honor.
If your plea was accepted, you'll give up the claim that the plea was a result of any promises other than negotiations that have been talked about and the amended count that you're pleading to, or threats, or that it was not your choice to plead guilty. Is it your choice to plead guilty today?
Yes, Your Honor.
Okay. You'll also be giving up the right to any trial issues. You won't be having a trial. You'll be actually pleading guilty to the case instead of having a trial. Is it your intent today to plead guilty to this attempted flee and elude fourth?
Yes, Your Honor.
All right, I'm gonna have you raise your right hand. Do you solemnly swear or affirm to tell the truth, the whole truth, and nothing but the truth
Yes.
under penalty of perjury?
Yes, sir.
Okay. I'm gonna bring your attention back to April 29th, 2022 at Martin Luther King and Barnes, City of Lansing, Ingham County. Were you at the Martin Luther King, City of Lansing address street on April 29th, 2022?
Yes.
And were you operating a motor vehicle?
Yes.
All right. Tell me in your own words what makes you guilty of attempted fleeing and eluding on the fourth degree.
Situation was when they got behind me, they hit their lights. I kind of accelerated a little bit. They turned their lights off. They see me at the gas station. They got out and took the rest of me and took my vehicle.
All right. So when they got behind you and they hit your lights, you knew that you knew it was a law enforcement Lansing Police Department vehicle.
Yes.
And your responsibility was to pull over at that time, correct? And instead of pulling over, you kept on driving, you accelerated, and they were able to catch up with you and stop you later.
Yes.
Anything towards the factual basis, Ms. Smith?
No, Your Honor. I'm
Anything, Mr.
satisfied.
Feigelson?
None, Your Honor. I'm
All right.
satisfied as well. Other than, Your Honor, I think it was an MSP, but I think that's zero.
Okay, so it was law enforcement
Yeah, right.
that you were identified. Okay.
Makes me stay.
All right, thank you. I find the factual basis and plea to be knowing, voluntarily, and accurately made. I find the factual basis to meet the attempted count one of flee and elude in the fourth degree. So we will refer this to probation.
Judge, I'd ask for immediate sentencing on this case, if I can be heard on that as to my reasoning.
Sure, and then I'll hear from the prosecutor as to their response. Go ahead, Mr.
Your Honor,
Feigelson.
Mr. McFadden is presently on probation up in the 30th Circuit Court, Your Honor. I think it's Swift and Sure sanction. So it's likely he's already going to be continuing on probation up in Circuit Court. So I don't necessarily know if placing him on probation down here would be appropriate, nor would having him be in a jail sentence. I would ask for fines and costs today.
Ms. Smith?
If I may have a moment to verify his probation status. Your
All
Honor.
right. Yeah.
Your Honor, I have a note from APA Matusko, who was assigned to Judge Kennedy's court from September 14th. It says that the defendant was sentenced to 18 months probation, no swift and sure adopt the recommendations from the PSI. So I don't know exactly what his probation entails, but it does appear that he is on probation in the 30th Circuit Court. To me, it does make sense that he be on probation in one court versus two. So I would leave it to the court's discretion.
All right, I'm leaning towards, I don't want him to have to be on probation to two courts, but I'm gonna run a CCH just so I know exactly the nature.
Your Honor, I have the PSI here. With Judge Kennedy, he is on probation for carrying concealed weapon and possession of a firearm by a felon. He has 4 prior felonies, 2 prior misdemeanors. The recommendation from probation was 18 months, no alcohol or drugs, drug and alcohol testing as required, outpatient substance abuse treatment if referred, MRT or cognitive behavioral programming, no assaultive, and then just your other standard probationary terms, Your Honor.
All right.
Judge, he is doing, from Mr. McFadden, he is doing MRT every Wednesday. He's been actively going since September. I imagine, when do you expect to be finished, do you know?
He said if I do good in 7 months, I can do it 17 months.
Okay.
So what is that, every Wednesday?
He's doing MRT every Wednesday. Moral recognition therapy. It's a program that I think a lot of judges in the circuit court utilize, Judge.
Well, based on the criminal history, I will go to immediate sentencing, but I don't think fines and costs are the answer here. I think that for a 1 year, some amount of jail time is necessary.
Judge, I just spoke with Mr. McFadden on that issue. I think we can refer this to
For the probation?
Yes.
All right. That seems like a valid point here. So let's refer to probation, which is the initial thought process. We'll figure out the probation's overlapping, but we'll refer to probation, and that'll be,
March 14th.
okay, so the sentencing will be March 14th, 2023 at 1:30. And you're to refer to the District Court 54A probation. Within, you're here, so you might as well get it done now.
I can show him where to go, Your Honor.
Yeah, so I'll refer you to probation. Just answer any questions. They'll refer it to me and we'll sentence you on May 14th to see what options are available to us, okay?
Okay.
And let them know that you're already in probation in circuit court, so they'll have that information.
What do I, since I go see my PO on the 17th of January, so what do I tell my PO? I told my PO, like, you know what I'm saying? Because this charge wasn't.
Yeah, you can tell them that you pled to a misdemeanor and then you were referred to probation and you went through the process, and those 2 POs might want to talk.
I would make sure you have releases signed so that both courts can get information together. Make it
Right.
easier for you.
Okay.
It's my standard practice to also inform MDOC probation when a second plea has been entered, so I'll independently alert
Okay.
probation as well.
All right, so you referred to probation today. Mr. Feigelson, your attorney will walk you down there, and we'll see you back here on March 14th at 1:30, okay,
That's
sir?
the person I assume, correct, Judge?
Correct.
Thank you, Your Honor.
Appreciate it.
Thank you.
I'm gonna go talk to Mr. Adams.
I'm ready
Thank you,
on
Wendy.
Grady Jones. It's gonna be an exam. I got it. It's on it. Yeah.
I don't know if they put him on that video or not.
On the South arraignment.
Yeah. I don't.
Is Mr. Jones there? From the Ingham County, South Arraignment. Mr. Sarts, I was just checking to see if he was on audio but not video, but it appears he's not there at all right now.
And Your Honor, I have a couple of PEs that are scheduled in front of Judge Ward. Yeah, I can stick around for a few more minutes. Otherwise, worst case scenario, we could always handle the plea next week. I'm not sure what's going on, but certainly I'll stay on for now.
All right. If Miss Smith, we'll get Miss Smith in here, and then we might have to just leave this on for next week.
Yeah, I mean, I'm fine sticking around a few more minutes, Your Honor, but understandably, I'm sure Judge Ward wants me to move forward with a couple PEs I scheduled for 9 o'clock. So.
All right. Look, let's see if we can either adjourn this a week or get it done today.
Okay, great. Thank you.
Jones on the South arraignment
Oh.
so we'll just move. Mr. Sarch, are you available?
Yeah, I'm here right now.
All right, so let's just keep those on for next week, since that seems to be a better plan than waiting on everybody. So we're on the record in docket 22-03365 and 22-00887. People of the state of Michigan versus Jeffrey Jones. These are both set for probable cause conference today. Attorney appearances for the record, please.
Good morning, Your Honor. Assistant Prosecuting Attorney Melanie Smith on behalf of the people.
Good morning, Your Honor. Jacob Sarch, the fourth Assistant Public Defender, appearing by Zoom on behalf of Mr. Jones. Mr. Jones is in custody at the Ingham County Jail.
Okay, and Mr. Jones was at some point in time going to be brought as a part of the arraignment proceeding, with the understanding that we may be able to resolve the case today, but it appears just because of time constraints, so we'll be leaving it on for preliminary examination for January 6th, 2023 at 8:30. Is that correct, Mr. Sarts?
That's correct, Your Honor. People had made a plea offer to Mr. Jones, a one-year misdemeanor, a domestic violence second. Mr. Jones indicated yesterday to me that he was interested in accepting that. We were scheduled for 8:30 this morning. Unfortunately, I have 3 prelims scheduled for 9 and 10 o'clock respectively. So I appreciate the court's understanding, and I expect we'll be proceeding with a guilty plea next week. But if that information changes, I'll reach out to the prosecutor immediately.
All right, perfect. And anything else, Ms. Smith, on either one of these files?
No, Your Honor, thank you.
All right, so we'll leave it set for preliminary examination with January 6th, 2023, with the understanding that there is a misdemeanor offer plea out there, and we'll go from there. Okay, Mr. Sarts?
Thank you, Your Honor.
Thank you. That's all for the record in 22-03365 and 22-00887.
Thank you, Your Honor.
We're on the record in docket 22-03268. That is people of the state of Michigan versus Anta Marvel, Grady Jones. Will the parties please introduce themselves for the record?
Yes, good morning, Your Honor. Melanie Smith, Assistant Prosecuting Attorney on behalf of the people.
Thank you, Honor. Field Court Rider on behalf of Mr. Grady Jones, who's seated at defense table.
And sir, you are, correct me how to pronounce your name, Antana Marvel, Grady Jones.
Antonio Marvell, Grady Jones.
Antonio Marvel, Grady Jones.
Yes.
All right. Ms. Smith, this is the time set for a preliminary examination. How are we proceeding today?
I will be asking the court to proceed with the testimony of the victim, Ashley Harris.
All right. Are there any preliminary matters to come to the court's attention before we start the preliminary examination?
Not from the people.
I don't think so.
All right. Yeah, we have an empty courtroom, so you may proceed.
Thank you, Your Honor.
All right, ma'am, I'm going to have you please step right in front of me. All right, and please state your name and spell your last name for the record.
Ashley Harris, H-A-R-R.
And raise your right hand. You solemnly swear or affirm to tell the truth, the whole truth, and nothing but the truth under penalty of perjury.
Yes.
Right, go ahead and have a seat here, and I'll have you project for recording purposes. Ms. Smith, you may proceed when you're ready.
Thank you, Your Honor. Ms. Harris, like the judge just said, there's a little microphone in front of you. We just need you to speak nice and clearly so that Ms. Golden back there can record everything you say, okay? Ms. Jones, why don't you go ahead and tell me where you were living on May 24th, 2022?
Miss Harris?
Yes, sorry, what did I say? I'm so sorry.
515 South.
Okay.
All right, you're
Can
good.
you do a little bit
Yeah,
higher?
you have to talk right into the mic and talk as loud as you can.
515 South Butler Boulevard, apartment 4, Lansing, Michigan, 485.
And who were you living there with?
Can I just say AJ?
Sure, who was AJ? Tell me about
AJ
AJ.
is Mr. Grady Jones.
And is Mr. Grady Jones in the courtroom today?
Yes.
Can you look at him and tell me what color his shirt is?
Navy blue.
Identification for the record, Your Honor.
Any objection? Without objection, the witness has identified the defendant.
And what would you describe your relationship as with the defendant?
We were in a relationship, like a romantic relationship,
Okay, how long had you been dating?
since 2019.
And had you lived together that whole time?
Yeah, on now.
Do you have any children together?
Yeah.
And so on May 24th, at your apartment, tell me about what happened.
He asked me to borrow some money to pay his phone bill, and my account was on my phone. So he sent himself like $160, which is one of those like $60. And I looked at my, like, you know, like the backlog of it, and he was like taking money from me. So we
I'm
got
sorry.
into argument about it.
Yeah, so speak up a little louder so defense counsel can hear you and we can get a good recording.
Okay, that morning, he asked me to borrow money to pay his phone bill, which was $60. And when I looked at my account, he had taken way more than $60. So I asked him what he was doing with it. We got into it, and I said, I'm tired of taking care of you because I've taken care of you and everything. He wasn't helping with bills or nothing. So we got into it. Honestly, can't remember what happened, why I ran into the bathroom. Right, I can't remember that anymore. But I remember we got into a fight. I called the police because I was livid at that point. I didn't put my hands on him. He didn't put his hands on me, but I don't remember why I went to the bathroom.
Okay, but at some point in an argument, you went to the bathroom.
Yeah,
To
and I
remove-
closed the door
to
because
get
I
some
wanted him
space.
to leave and he wouldn't leave. I think
Okay.
that's what happened. I wanted him to leave. He wouldn't leave. He was just sitting on the couch.
Okay.
So then I went to the bathroom, called the police, and he heard me and he got mad. And when I came out the bathroom, he was punching the door prior to me coming out. But when I came out, I got my phone, right on the floor, and we began to tussle.
Okay. And so when you went into the bathroom, did you close the bathroom door? Okay, and so when you say he was pounding on it, you mean he was pounding on the bathroom door that you were inside of?
Yes.
Okay, and so he heard you call the police, took the phone and threw it, and then what happened?
We just got into like a tussle. I don't remember what happened.
Okay, at some point, did the defendant put his hands on you?
Yes.
Tell me about that.
We were tussling. I was hitting him as well, and he tried to choke me. That's
Okay.
like his thing.
Tell me what you mean by choking.
Choke me. I couldn't breathe.
I saw that you put your hand right at the front of your throat here. Is that where he touched you?
Yes.
Was that with one hand or two hands? And did he apply pressure? Did it cause you to have any trouble breathing? And how were you feeling at that time?
I'm like fight or flight.
Tell me more.
I had to fight so I could get out of it.
And so when you say you had to fight, did you touch him first or did he touch you first?
Well, he touched me first because he grabbed my phone. When he grabbed my phone, that's when I tried to like jump on him. Don't break my phone. Luckily it didn't break. But, You know what I'm saying? So we got into a tussle. That's like he grabbed my neck immediately. So I'm like trying to grab at him and get him off and like punching him and stuff.
Were you able to actually connect with 911 while you were in the
Yeah,
bathroom?
I was having a conversation.
Okay, and so when he took the phone from you, obviously you were disconnected from 911?
I think she was on the phone. Let's put the phone back up. Put the phone back up. He didn't at a certain point. We were fighting for maybe 3 minutes.
Okay.
And when we left, he threw it again. After picked it up, threw it in the kitchen. Pick it up, and I believe she was still on the phone because she got in his hair.
Okay. And after he left the house that day, how did you feel?
I was always depressed with it.
Tell me about being depressed.
It's very cool. So he also
You'll have to speak up just a little bit more, ma'am.
I know it's hard. Take your time. There's some Kleenex there too.
So maybe for trash. So I would never have to use. I'm sorry, he just always made me feel like trash, and I was never happy when he was there.
Tell me more.
He was just using me the entire time for a place to live. He admitted that. So.
Was this the first time that he had gotten violent with you?
No, but it was always, I did it first. I attacked him. He's not really violent at putting his hand on me. He's just a user.
Okay.
So I will attest to that. He was not violent. I did provoke that. So I was yelling at him in his face. You know. So, but it was out of hurt and pain.
But on this date, on May 24th, he started the physical altercation. Is that fair to say? And any actions that you took against him were in self-defense?
Yeah.
I have no further questions.
Cross-examination, Mr. Coltrider.
Yeah, just briefly, Your Honor. Now, ma'am, you said he took your phone initially, and then you said.
that a yes or no?
Yes.
Okay, thank you.
And then I believe you said then you had a tussle following that.
Yes.
After he took your phone, did you touch him first or did he touch you first during
I
that?
touched him.
tussle? Okay. And did you strike him?
No, I was just like grabbing at his hair. Just
Push him in
grabbing his
any way?
hair. That was like my effort to grab his hair.
Did you push him in any way?
Yes, I
Okay.
did.
Now, this was on May the 24th, correct?
Yes.
Subsequent to that time, sometime in June, did you have a charge against you for domestic violence?
Your Honor, objection.
Legal objection.
A, relevance. We're not talking about what happened a month after this. And B, I believe that defense is trying to get inadmissible character evidence.
Response?
I think it goes to motivation, Your Honor.
Well, I mean, there's a Michigan rule of evidence that indicates that self-defense and character evidence can come in for self-defense, depending on the defendant's perspective. I'm going to allow it, but it's not going to go to the substantive nature of what I've heard already. Okay, so I'll allow it. Objections overruled.
Yes.
Okay. And that was in June? How long would you say this whole altercation took?
I got maybe 15 minutes. I was yelling for a good 30 minutes.
Okay. And when's the last time you've seen my client?
So like around December. Early December. We're gonna hang out on the 6th. That's what that day.
All right, say it again, ma'am.
I said the last time I'd seen him was like December.
December?
Yeah.
Okay.
And so you've been together since 2019?
Mhm.
And during that time, from your estimation, how many times the police responded to your house?
Maybe upwards of 7.
About 7, you're saying?
Mhm.
Okay.
A lot.
Now, at your residence, do you have any cameras or anything
No.
inside the house?
No,
Do you have any cameras on the porch?
no,
And you made contact with the police when you called 911?
yes.
No further questions, Your Honor.
All right, thank you, Mr. Coltrider. Any redirect?
Yes, Your Honor. Mr. Coltrider mentioned a criminal case that you had regarding domestic violence. Isn't it true that that case was dismissed?
Yes.
And while we're speaking of a history of domestic violence between the two of you, after this date that we're talking about, May 24th, were there other times that the defendant assaulted you?
Not personally.
Not first?
No, I always was, I hit him first or broke something. I broke something of his, like his game or TV. Then he would like run at me. You know, he was not like violent. He's not a violent person. He's not towards me. And I would do that. I have to be honest about that because I struggle with these issues.
I appreciate your honesty, but wouldn't you agree with me that it's different to break something versus hitting someone?
Absolutely, you're correct.
I'm going to object, Your Honor. I think the question was asked, answered.
Okay. I'll overrule the objection and allow the answer to come in.
Thank you, Your Honor. You said you always hit him first. Did you hit him first on September 9th? Yes.
No, I threw his game.
You threw his game, and then what happened after that?
And then I tried to go, I went to the kitchen because he was coming at me. I wasn't gonna let him hit me. And he didn't let me grab anything. And we got into a tussle then. And I could think of a coffee cup and a hot water. And then this car was.
Okay. But what I'm getting at is this wasn't an isolated incident.
Yes.
Are you fearful of the defendant?
No.
Do you think that he would assault you again?
No.
I have no further questions, Your Honor.
All right. May this witness be excused from the people,
Yes, Your Honor.
from the defense?
Yes, Your Honor.
All right. Without objection, the witness is excused.
Stay in that little room. I'll be right there, okay?
Do the people have any further proofs?
No, Your Honor.
Okay. Do the people rest?
Yes, Your Honor.
Did the defense have any further proofs today?
No, Your Honor.
All right. Motion for bind over?
Thank you, Your Honor. The people would ask that this honorable court bind this matter over as charged based on the testimony of the victim, Ashley Harris. Ashley stated that on May 24th, 2022, at her residence, which is in the city of Lansing, that her and her boyfriend at the time, they'd been dating for quite a while, had an altercation to the point where she was fearful that she went into the bathroom, closed the door, and called the police. While she was on the phone with the police, the defendant was banging on the door, attempting to gain entry. Once he did, he took her phone and disconnected her from her phone and therefore her from 911 and prevented her and obstructed her from getting the help that she needed from the emergency dispatch, which goes to count 2. After the phone was disconnected, he placed his hands on her. Specifically, he used one hand to place pressure on the front of her throat, which is the trachea area. That caused her trouble to breathe, which would go to count 1 assault by strangulation. And any hands-on-hand physical contact between the parties would constitute domestic violence given their relationship. And at this point in time, the people don't need to prove that it's a second offense. It's just a notice. So I believe that proofs have been sufficiently shown here today by probable cause that the crimes were committed and that the defendant did commit them. We ask that this be bound over to circuit court.
Thank you, counsel. Response?
Yes, thank you, Your Honor. I think testimony you heard today was that the phone was taken away from the defendant, which after that, I think she testified that she placed her hands on him first. I heard indication today that there was a prior domestic against her. There was indications that police had responded to the house at least 7 times. I think she indicated she was not fearful of the defendant on that day. In terms of the domestic violence, obviously my client didn't take the stand today, but I would propose that when she said she touched him or pushed him or tried to re-grab the phone back, he was simply defending himself at that point. Based on what I've heard today, I would indicate to the court that possibly interfering may stand if they can prove at trial that the phone was actually taken from her. But I would indicate to the court that I don't see a domestic violence here. I don't see any fearfulness on her point. She indicated she touched him first. And there was some indication that possibly he had grabbed her around the neck. But again, I would say that was in response to what was happening prior to that.
Thank you. The standard for preliminary examination is probable cause. Probable cause out of the Fourth Amendment being the second lowest standard in criminal law, reasonable suspicion being the lowest standard. I do find there's probable cause evidence to find that on May 24th, 2022, at 515 South Butler, apartment 4 in the city of Lansing, Ingham County. So that's probable cause of the date, venue, location. ID was made by the witness on the stand. The witness, Ashley Harris, testified that she was in a dating relationship with the defendant. And on that May 24th, in regards to the offense elements, that there was what seems to be a mutual tussle that was escalated at some point. But previously, she was on the phone with dispatch, and the phone was taken from her at some point in time and thrown from her while dispatch was on the phone, which I believe meets a probable cause level of did willfully maliciously prevent, obstruct, or delay by means sending conveyance or delivery through the telephone or telephone line at a probable cause standard. That felony is met in count 2, that the defendant prevented, obstructed, or delayed any sending of authorized communication and did so willfully and maliciously. In count 1, after somewhat of a tussle, the witness was clear that she was choked by a hand. In regards to choke, could not breathe, applied pressure to her neck area, was not able to breathe. That would make, based on count 1, that would make by probable cause level that the defendant did make an assault upon Ashley Harris by strangulation or suffocation at the location, offense, venue, ID, and date indicated in the complaint. Count 3, which is domestic assault, which is a misdemeanor, will follow the 2 felony counts to be bound over. So I'll bind over to circuit court on count 1 and count 2. Count 3 will follow, and that will conclude this time in district court. Any future time will be in circuit court, where both these felony counts are bound over to, and that'll be the trial court. Anything else for the record from the people in regards to 22-03-268?
No, Your Honor.
Anything, Mr. Colwriter?
No, Your Honor.
All right, thank you. That's all for the record in this file. And since we have the prelim, business assignments, right? All right, since we have the prelim, you'll get your next date from your attorney, Mr. Colwriter.
Thank you, Your Honor.
Thank you. We're on the record in docket 22-03279. That is People of the State of Michigan versus Dylan Schramm. Will the parties please introduce themselves for the record?
Good morning, Your Honor. Assistant Prosecuting Attorney Melanie Smith on behalf of the people.
Karen Robinson, Assistant Public Defender. Geez, repeating everyone today.
Good. It's
For
okay.
Dylan Schramm, who's standing to my right.
Sir, you are Dylan Schramm?
Yes.
Okay. This is the time set for a preliminary examination in the matter. Ms. Smith, how are we proceeding?
Your Honor, I believe the intent for today is for the defendant to enter a no contest plea. The basis for the no contest would be intoxication at the time of the event, and therefore lack of memory. The plea would be to an amended count 1, attempted resisting and obstructing a police officer. So that would be 750.81 D as in dog, parent 1, parent A. That takes it from a felony to a misdemeanor punishable by 1 year and or $1,000. Upon successful plea to amended count 1, counts 2 and 3 would be dismissed. There is a Killebrew agreement for the defendant to receive no additional jail at the time of sentencing, understanding that there will be a term of probation at the court's discretion. Part of this resolution is a dismissal of a pending case in the 55th District Court. So as a added provision for bond release and eventually probation, we would request that the court add a no contact order with Destiny, D-E-S-T-I-N-Y, Parker, P-A-R-K-E-R. And then restitution for both files. I believe that is a full statement.
Do you have a number for the dismissed file? Do you know what file that is?
I have my internal number. Let me get you the court number.
I've got it. That number is 2200635 SM.
Okay.
Thank you.
All right, I'll restate that plea agreement for the record, and then Ms. Robinson, you can correct me if I made any mistakes. This is a no contest plea. The basis is intoxication at the time. It's to plead to amended count 1, attempted R&O under 750.81 D, parents 1, parents A. That's a 1 year and or $1,000. Counts 2 and 3 are to be dismissed, along with file 22-00635. As part of this plea agreement, there is a Killebrew of no upfront jail. Also, as a part of this plea agreement, there's to be no contact with the victim, Destiny Parker, and restitution is to be made on both this file and the dismissed file. Is that a correct statement of the plea offer?
Yes, Your Honor. And also, I have talked with Ms. Smith, and she will be consenting to releasing him to a PR bond if he gets a bed into residential treatment program, and we are working on that. While it's not a Killebrew at this time, I would just like a note in the file in case I, for some reason, am unavailable that day, just because of the time-sensitive nature of getting people into beds at residential programs.
And is that your understanding, Ms. Smith?
That is correct. We would oppose any modification until it's a confirmed placement in treatment and ask for that to be a direct placement so that there's not a time where Mr. Schramm is out of custody, so to speak.
Right. So for the record, I'll indicate that the defendant is to be released, or Mr. Schramm is to be released on PR bond if he's able to get into rehabilitation. The people do not oppose a direct placement into rehabilitation.
Thank you, Your Honor.
Thank you.
And Mr. Schramm, you've heard the lawyers, you've heard us all talk. Is that your understanding of the plea agreement?
Yes.
Okay. You understand today, so Ms. Robinson may make inquiry of your client's no contest plea concerning this matter. All right. You understand the ultimate penalty, other than the Killebrew of no from jail, which you can withdraw your plea if I don't follow that agreement, is 1 year and or $1,000. Do you understand that in
Yes.
regards to this amended count?
Yes.
Okay. Now, if you plead guilty today, if you plead no contest today, you'll be giving up the following rights, and I'll walk you through those rights. All right, sir?
Okay.
All right. So in this misdemeanor, in this file, and in this misdemeanor trial that you're pleading no contest to, you have the right to be tried by a jury. You have the right to be presumed innocent until proven guilty. You have the right to have the prosecutor prove beyond a reasonable doubt that you are guilty. You have the right to have the witnesses against you appear at trial. You have the right to question those witnesses against you. You, of course, are represented by public defender Erin Robinson. She would contest any charges or cross-examine any witnesses that are brought by the people in this misdemeanor case. Do you understand that, sir?
Yes, sir.
You have the right to have the court order any witnesses to appear at trial on your behalf. You have the right to remain silent during the trial. You have the right not to have that silence used against you, and you have the right to testify at trial if you choose to testify. Do you understand all those rights that you're waiving today?
Yes.
All right. If your plea of no contest is accepted, you'll be giving up any indication that this was not a result of your own wish to plead no contest. Do you wish to plead no contest today, sir?
Yes.
All right. You'll also be giving up a trial in this right, so you won't have an appeal to trial because you'll be pleading no contest. Do you understand that?
Yes, sir.
Is it your intent today to plead no contest to the charge?
Yes.
All right. It's my understanding that the factual basis for the no contest plea will be in the Lansing Police Department police report, case number 2151902-374. Is that correct, Ms. Smith
That's correct, Your Honor.
and Ms. Robinson?
I believe so.
All right. And so we'll look at it for a factual basis for the attempt R&O in count 1. And we have on March 15th, 2021, which is the date, location of West Michigan and North Verlinden, City of Lansing, Ingham County, which is the venue and location. The officer Trevor Allman was dispatched to Sexton High School.
That's where I was.
He's just gonna be listening.
It appears that the defendant was damaging some vehicles and assaulted the police officers on that date at that time, and then was transported to Sparrow Hospital. So I do believe that in count 1, did attempt to assault, batter, wound, or pose Officer Allman, knowing him to be a police officer. And it indicates here that the officer was in Lansing Police Department office, as in clothing and in a Lansing Police Department marked vehicle. Anything in regards to the factual basis for the no contest plea, Ms. Smith?
No, Your Honor. We're sorry.
Anything in regards to the no contest plea, Ms. Robinson?
No, Your Honor.
All right. I believe that the factual basis for the no contest plea to be made. So that would be a no contest to count 1. Counts 2 and 3 are dismissed.
Judge, I think you have to ask him if he pleads no contest or what he pleads.
Oh,
I'm sorry, just for the record,
Yeah,
to be clear.
So you are pleading no contest to this, correct?
Yes.
Okay. And I don't think there's anything else after that.
No, I just,
All right.
you have to say.
Yeah, I thought I covered that, but I may
No
have not
worries,
have.
I might have missed it.
So I'm going to refer this to probation. And so I'm going to refer to probation. And probation will contact you while you're incarcerated in jail in order to take some information from you. So I have that information so we can decide what options we have at sentencing, okay? And so they'll talk to you. And our sentencing dates are a little out right now, but with the understanding that if you get into rehabilitation, we'll release you right towards the rehabilitation, okay?
Okay.
All right. What's the sentencing date for this matter?
March 14th at 1:30.
March 14th at 1:30 is the date of sentencing.
And Your Honor, just for purposes of the record, because the dismissal of the case in 55th is part of this resolution, and that is a Crime Victims' Rights Act, I will be notifying the victim in that matter, Destiny Parker, that she may make a statement to this court at the time of sentencing.
Okay, that's fair. And as a part of this, there will be a no contact with Destiny Partner as a part of probation in this matter.
I have no intention on doing so.
Let's issue it now, so you can put it in the computer now. Since we know it's gonna be a part of it, and I don't think it's contested.
That's correct.
All right. So your sentencing date will be March 14th at 1:30. All right, Mr. Schramm. Anything else for the record in docket 22-03279? Ms. Smith?
No, Your Honor, thank you.
Anything else, Ms. Robinson?
I would just add briefly that my social worker with my office is working currently on getting him into residential treatment. So we don't need probation, I guess, to look at that. We have that covered on our end. So.
Okay, perfect. All right, anything else for the anything on file 22-03279, Ms. Smith?
No, Your Honor.
Ms. Robinson?
No, Your Honor.
All right, you're all set. We'll see you back on March 14th at 1:30, and probation should come down to see you in this regard. Okay, sir?
Okay.
That's all for the record on that file, and you want the no contest?
Thank you, Your
Back
Honor.
cases back.
I think we're good on Mark Adams. You want to grab him while you're down there? I'll find him while you do it. How about that? And Lance Travis is not here yet, Your Honor. I don't know how much time.
We'll see what Mr. That's Mr. Feigelson, right?
Yes.
All right. And then the only one left is Mr. Porter, right?
Yep. So Adams is going to be a misdemeanor plea. Porter is going to be an exam. And then I will find Mr. Feigelson and
All right.
see if he's heard from Mr. Travis.
If not, we can do both of those at once.
Sounds good.
All right, I will see you after lunch.
All right. We'll get through some pre-trials,
Yep.
which I don't think is going to be a usual for Thursdays.
No. Hopefully not.
No, it's
so
not.
Hard
It's-
with our
It
schedule.
is, I know, and we're just trying to move some Monday stuff because we didn't have any Mondays,
Yeah, I know it's hard
Yeah.
this time of year.
In my defense, I did ask Mr. Cornish and Mr. Watson. Neither one ever answered me. I
Yeah.
gave them
No.
a week.
We're fine.
I just say I exercise patience. for
No,
two
you're
weeks.
okay.
No, you guys are busy.
Yes, this
Yeah.
is the
It's
last.
hard, and I'm moving up to a felony docket soon, so it's like
Are you really?
I have double caseload right now. Yeah.
Uh, Well, congratulations on that. That's kind of fun running a felony docket.
Yeah, I mean, it's not my first rodeo running felonies.
Yeah.
So
It's a nice change of pace.
it's a different change of pace. I don't know, but I've always had I always love misdemeanors just because
Yeah.
it's like shoot from the hip, like whatever,
Right.
like let's figure it out.
Yep.
Felonies, not so much.
Not so much. Bigger in docket 22-02526. That's people of the state of Michigan versus Lance Travis. Will the parties please introduce themselves for the record?
Good morning, Your Honor. Melanie Smith, Assistant Prosecuting Attorney on behalf of the people.
Good morning, Your Honor. Assistant Public Defender Stephen Feigelson on behalf of Mr. Travis. Your Honor, I do not see him here this morning. Let me give you a little history. I think the court may be aware of it, but I'll just, I know we had court a few weeks back, Your Honor. My client arrived a little late. I think he went to the wrong court. The witnesses at that time didn't appear, and I don't believe that they're here this morning. The court did give us an adjournment because Mr. Travis was a couple of minutes late. Obviously, he's not here this morning. I'm not certain where his whereabouts are this morning, Your Honor. But I would ask I'd ask for an adjournment again, Your Honor, if it's possible.
All right, Ms. Smith.
Your Honor, I'd be asking for a bench warrant and bond forfeiture. This is an assaultive crime. It's not his first time being late to court. We were scheduled at 9:30. It's 10:40, and I think an immediate bench warrant is appropriate.
All right, this was scheduled for 9:30. It is 10:40. We did have, he appeared late and we adjourned it for good cause last time. I don't believe the defendant waived his right with a prelim within 21 days. But we adjourned for good cause because he was late and we didn't bench warrant him on that time. I believe that was on just, and we set it for December 29th. So I'm going to issue a bench warrant bond forfeiture. Mr. Feigelson, if you're able to get him here by 4 today, we can revisit it, you know. What's that? 3:30.
Yeah, that's fine.
Yeah, by 3:30. Sometime this afternoon, if you're able to. Other than that, it's bench warrant and bond forfeiture. Defendant failed to appear.
Thank you, Your Honor.
Thank you, Your Honor.
When he comes into court, I can't talk to him, okay?
This was twice he would have had a dismissal, but he couldn't show up.
Or so you think. You don't know what officers I have here and who I don't.
Yeah, but I think you need the officers in there, too.
And I have officers.
No, you don't need that. You need this one, the other end.
All right, we're on the record in docket 22-03483. That's people of the state of Michigan versus Mark Adams. Will the parties please introduce themselves for the record?
Good morning, Your Honor. Melanie Smith, appearing on behalf of the people.
Good morning, Your Honor. Assistant Public Defender Stephen Feigelson on behalf of Mark Adams, who's standing to my right. Your
And sir,
Honor.
you are Mark Adams?
Yes, sir.
All right. This time set for a preliminary examination. Ms. Smith, how are we proceeding today?
Thank you, Your Honor. Today, I believe the defendant's intention is to plead guilty to count 3, domestic violence, and count 4, domestic violence. In exchange for those guilty pleas, counts 1 and 2 would be dismissed. And then that's it.
See, so plead guilty to count 3 and count 4 domestic assault. And counts 1 and 2 are to be dismissed. Mr. Feigelson, is that your understanding of the plea agreement?
Yes, it is, Your Honor.
May I inquire of your client of the plea agreement and his advice of rights?
Yes, Your Honor, you may.
All right. So my understanding, sir, is you're going to plead guilty to counts 3 and 4. The ultimate penalty in counts 3 and 4 are 93 days in possible penalty of 93 days and or $500. That's what your intent to do today is?
Yes, sir.
And when they plead to counts 3 and 4, counts 1 and 2 are to be dismissed.
Yes, sir.
All right. So if your plea is accepted, you will not have a trial of any kind. So I'll walk through some of the rights you'll be waiving in regards to your plea instead of going to trial on both of these misdemeanor counts. You have the right to be tried by a jury. You have the right to be presumed innocent until proven guilty. You have the right to have the prosecutor prove beyond a reasonable doubt that you are guilty. You have the right to have witnesses against you appear at trial. You have the right to question those witnesses against you. You, of course, are represented by Attorney Steve Feigelson. He would cross-examine or contest any charges brought against you at trial. You understand that, sir?
Yes, I do.
You have the right to have the court order any witnesses that you may have in your defense. You have the right to remain silent during the trial. You have the right not to have that silence used against you. And you have the right to testify at trial if you choose to testify. Do you understand you'd be waiving these rights if you plead guilty?
Yes.
Okay. If your plea is accepted, you'll give up the claim that the plea was a result of any promises other than pleading to counts 3 and 4, dismissing counts 1 and 2, and that it's your intent to plead guilty today. Do you understand that, sir?
Yes, sir.
You'd be giving up any right to an appeal from any trial because you're not having a trial, you're pleading guilty. So you'd be giving up any right to appeal anything that came out of trial. Do you understand that? Is it your intention to plead guilty today?
Yes.
Have you raised your right hand? Do you solemnly swear or affirm to tell the truth, the whole truth, and nothing but the truth under penalty of perjury? Yeah, I'm going to bring your attention back to December 13th, 2022 at 539 Avon, City of Lansing, Ingham County. Were you present at the 539 Avon address in the City of Lansing, Ingham County on December 13th, 2022?
Yes, I was.
And in count 3, which is domestic assault concerning Mercedes Cruz, can you tell me what you did to make you guilty of domestic assault involving Mercedes Cruz?
I put my hands on her.
Okay. And when you put your hands on her, that was an offensive touching of Mercedes Cruz to the best of your knowledge?
Yes.
And you did not do so in self-defense, sir?
No.
Okay. And she's a resident or former resident of your household, or you were in a dating relationship with
A
her?
relationship.
Okay. In count 4, there's an indication that on the same date and time, December 13th, 2022, at 539 Avon, City of Lansing, Ingham County, were you on that Avon address on December 13th, 2022 in the City of Lansing?
Yes.
In regards to count 4? Okay. Can you tell me in your own words what you did in regards to Angel Naranjo, which makes you guilty of domestic violence?
Yes, I waved a knife or pointed a knife at her.
All right. And to the best of your knowledge, that placed her in fear? Okay. And you did not do so in self-defense? And did you have a child in common with Ms. Naranjo? You have 2 children in common. All right. Any questions in regards to the factual basis, Ms. Smith?
No, Your Honor.
Anything, Mr. Feigelson?
Not with regard to the factual basis, Chair.
All right. I find the factual basis to be made as to counts 3 and 4 to be understanding, voluntarily, and accurately made. Counts 1 and 2 are therefore dismissed pursuant to the plea agreement. I'm going to refer this to probation, of course. You're currently incarcerated, sir?
Yes.
So probation will be out to talk to you.
May I address bond?
You may.
I think there is a bond set. I think it's a low cash with a percentage, Your Honor.
3,500, 10% is what I have.
That's what I thought. There are a couple of things to point out. He does have a place to stay. His parents are both here in the courtroom today. I did speak with them, and they had referred me to his brother, and they spoke to the brother. I can't confirm he can stay with his brother at an address of 724 West Grand River out in Okemos, Your Honor, and they are working to get him into some sort of a rehab facility for his addiction to substance abuse, Your Honor. I'd ask that he be given a PR bond to live with his brother, Your Honor, and then go from there. I do believe he will reappear for his probation interview and his sentencing as well.
Response?
Your Honor, my concern does not lie in returning to court. It lies in protection of the community, specifically the victims. I think that can adequately be addressed with a GPS tether, with exclusion zones and victim notifications. I would have no objection to a PR bond with those conditions.
How much time does the defendant have in on this file?
He's been in since the 13th, Your Honor, or thereabouts. Been since then.
So that's 16 days. Does the prosecutor have any CCH on this available to them?
Yes, Your Honor. Uh, 1998 domestic violence, 2006 assault and battery, 2006 assault and battery, 2022 a dismissed domestic violence. So all assault of crimes, Your Honor.
I'm gonna leave bond where it is at 3,500, 10%. That's a low cash bond for this type. This is this started out as 2 felonies. Now we're at 2 misdemeanors, but they're all assault of crimes. So I'm not gonna reduce the bond. $3,500, 10%. So the motion for bond is denied. Anything else for the record in docket 22-03483, Ms. Smith?
Your Honor, would you consider adding a GPS tether as a condition of bond? So when he does post it, assuming that he will, we can still have these victims protected?
I have, as a part of the pretrial release order, I would adopt anything. It's GPS tether is ordered to not release on bond without GPS tether exclusion zone 500 block of Avon. Must have CATS evaluation prior to release. May have third party assist with retrieving personal property. That's both as to Mercedes Cruz and Angel Nerano.
It was already in the order.
Perfect,
right?
Your Honor, thank you.
So it's already in the order.
Because we don't have a sentencing date, it's nothing.
Thank you, Mr. Feigelson. Sentencing date of?
March 14 at 1:30.
March.
The only issue I have with that is if he stays in jail. I mean, I think they might 7-day PR anyway, but if that doesn't happen, which I think it will, then maybe up to the maximum time anyway. But I think he's gonna get PR in 7 days anyway.
Yeah, so if he's PR'd in 7 days, he'll be PR'd with the order in place, okay? So, but I'm not gonna reduce the bond.
Fair enough.
All right,
Thank you, Your Honor.
all right, that's all for the record in 22-03483.
Thank you so much. Very helpful.
Thank you, Mr. Feigelson.
No problem, Judge. Thank you. I'll see you in a little bit. I think we're good this afternoon.
You do, you're my only plan.
I don't think we're gonna cut.
It's all.
Yes, but I have a good
on the record in docket 22-03311. That's People of the State of Michigan versus Jeremy Porter. Will the parties please introduce themselves for the record?
Good morning, Your Honor. Assistant Prosecuting Attorney Melanie Smith on behalf of the people.
And Assistant Public Defender Scott Nickel on behalf of Mr. Porter.
And sir, you are Jeremy Porter?
Yes.
Okay. This is the time set for preliminary examination today. Ms. Smith, how are we proceeding?
Your Honor, I'm going to be running a preliminary examination today. I believe I will have 2 or 3 witnesses. They are already sequestered.
All right. Are there any other preliminary matters to come to the court's attention before we start the preliminary examination?
Not from the people.
Anything from the defense?
Just that the court officially enter an order of sequestration.
Okay, so I will order, I will order a motion for sequestration. If anybody comes in, I will ask counsel to take a look to make sure that we don't have any witnesses sitting through other witnesses' testimony. With that understanding, Ms. Smith, you may call your first witness.
Thank you. That would be Officer Tyler Stover, and I'll go get him.
He's following me around today. Somehow all of my cases.
Is he?
He is one of the lead investigating officers.
Okay, Officer Stover, I'm gonna have you come right in front of me. Please state your name and spell your last name for the record.
Officer Tyler Stover, Tylerstover.
Please raise your right hand. Do you solemnly swear or affirm to tell the truth, the whole truth, and nothing but the truth under penalty of perjury?
I do.
All right, go ahead and have a seat. I'm gonna have you project for recording purposes. And counsel will probably ask you your name and spell your last name again for the record.
I will. Can you go ahead and state your name, please?
Officer Tyler Stover,
And spell it for me, please.
Tylerstover.
And how are you employed, Mr. Stover?
I'm employed by the city of Lansing. I work for the Lansing Police Department.
How long have you worked in that capacity?
I worked there approximately 1 year.
And were you working in your capacity as a police officer on November 26, 2022?
I was.
And that evening, approximately 7 p.m., were you dispatched to 811 North Pennsylvania Avenue?
I was.
And is that in the city of Lansing, County of Ingham, Michigan?
That is.
And what were you told about why you were going to that location?
Objection, Your Honor, hearsay.
Response?
Your Honor, it goes to the mind of the listener and what he knew about why he was going
Yeah,
there.
I don't think it's offered for the truth, so I'll overrule your objection.
I believe it was a weapons complaint.
And when you arrived at 811 North Pennsylvania, who was the first person you made contact with?
I made contact with the victim, Miss Duke.
And do you remember Miss Duke's first name?
I do not.
Okay. What did Miss Duke tell you about why you were there?
She said that.
Objection, Your Honor, hearsay.
Response?
Your Honor, I'm going to need to elicit a couple of hearsay statements in order to lay a basis for this testimony to come in under 76827C, which is an out-of-court hearsay statement regarding domestic violence. I would just ask the court for some leeway to allow me to lay that foundation.
If you're indicating that you're laying foundation for the hearsay statements in regards to the relationship,
Yes, Your
yep,
Honor.
I'll allow that. Objection's overruled.
Thank you. What did Ms. Duke tell you about why the police were called that day?
She stated that her boyfriend, Mr. Porter, had pointed a gun at her.
She said that it was her boyfriend.
Yes.
And did she tell you how long that they had been dating?
Approximately 6 years, I believe.
Did she tell you if they lived together?
She said that they stayed together at 811 North Penn.
And did she give you her boyfriend's name?
Yes.
And that name is?
Jeremy Porter.
Did she tell you if she and Mr. Porter had any children together?
Yes, she said that they had 2 children.
And what did she tell you more specifically about the defendant pointing a gun at her?
She said that he had been drinking all day. He walked inside after she had gotten the kids to bed. She was walking back down the stairs. She said he walked in, pointed the gun at her, cocked it, and yelled some profanities at her. I don't remember exactly what she had said.
Did she describe the firearm to you?
She did. She described it as a black and silver handgun, possibly a Smith and Wesson.
Did she tell you what happened after he pointed the gun at her?
She said that he left shortly after.
Did she tell you how he left?
In his Jeep, maroon colored Jeep.
And did she provide a partial plate for that?
She did. She provided a partial plate, 067 David.
And did she tell you any information about where the defendant may have gone?
Objection, Your Honor, hearsay.
It's still relevant to the statement about the injury or abuse that occurred.
Response?
Yes, under MCL 768.27C, which is what the people are using to attempt to admit this evidence, under subpart 1, subpart A, statements are admissible if all of the following are possible, is subparagraph 1. Subparagraph A says the statement purports to narrate, describe, or explain the infliction or threat of physical injury upon the defendant. Where he left after an incident allegedly occurred is not describing, narrating, or explaining the threat of physical injury. And so I would argue that this is specifically is not admissible.
Response?
Your Honor, I think that it's still describing the incident. This is an ongoing threat. This person who just assaulted her is armed with a gun, and she's still in fear. So I think that it absolutely should fall under the exception.
I'm going to sustain the objection. I think this is a little bit after the fact. I think she's narrated her experience in regards to the assaultive behavior, but where's he going? I think is a little further than the statute would allow. So I'm going to sustain the objection.
Thank you, Your Honor. What did Miss Duke tell you about how she was experiencing these events?
She said she was scared. She was concerned that Mr. Porter would come back to the residence that night. And she asked me if I was going to go look for him, make sure that she was safe.
Okay. And without saying what she told you, did she give you some information about some information that would help you in that quest?
She did. She
Okay.
she described the vehicle and where he works.
Okay. Did she describe Mr. Porter to you?
She did.
And did you later come in contact with somebody who matched that description?
I did.
And did you find out the identity of that person?
I did.
And did you confirm it was Mr. Porter, Jeremy Porter?
I did.
Is Mr. Jeremy Porter present in the courtroom today?
He is.
And can you tell me the color of his shirt?
He's wearing an orange shirt.
Identification for the record, Your Honor.
Objection. Any objection?
No objection for the purposes of preliminary examination.
Without objection for preliminary examination purposes, the witness has identified the defendant.
Thank you, Your Honor. And tell me about when you made contact with the defendant.
When I made contact with him, I was at the dealership or auto shop at 925 East Oakland. I was driving through the area and I observed a maroon colored Jeep backed in the parking lot there. So I made my approach from the west, which was behind the vehicle. I looked at the plate.
And where was that, sir? I couldn't hear you when you said where that was.
925 East Oakland.
Okay.
And is that here in the city of Lansing as
That
well?
is also in the city of Lansing.
Thank you. And so you approached the vehicle, and what was your purpose at that point?
To see if the plate matched and see if that was occupied by anyone.
And what did you observe?
I observed, I walked up to the driver's side of the vehicle and I saw Mr. Porter asleep in the driver's seat of the vehicle. And at that point, I backed off and called for additional units.
Okay. And once additional units came, what was your next course of action?
We attempted to contact the supporter. He was asleep pretty hard in the driver's seat, so it took us a few minutes to wake him up. But we eventually made contact with him.
And as part of that contact, was the defendant searched?
He was.
And do you know if anything was recovered on his person?
He had a set of keys on him to the building where he worked at 925 East Oakland, as well as keys to the Jeep that he was in.
Okay, so the keys to the business of the parking lot he was in?
Correct.
Okay, and how did you come to find out that those keys were in fact for that building?
Another officer, Forbes, went and checked the door. He didn't enter the building, but he checked to see if the key would open. It did.
Okay. Did somebody make contact with the owner of the business?
Yes, Officer Dalen, the owner of the business actually called 911 because he saw on the security cameras that there were officers outside his business.
Okay.
So it was a separate 911 call. He called and then Officer Dalen made contact with him over the phone.
Okay. And at some point that evening, did you or other officers obtain permission to enter that building?
Yes, I believe it was Officer Dalen who got permission from the business owner to enter the building. So
And were you part of the search of the building?
I was.
And during your search of the building, did you find anything that was relevant to this investigation?
We found 2 firearms. One of the firearms matched the description that Ms. Duke described. It was a black handgun, and it was a Smith & Wesson.
You said you found 2 firearms?
Correct.
What was the other firearm?
The other was a black Taurus handgun.
And to your recollection, were those firearms loaded?
I don't recall. I know there was loaded magazines, and I believe that the Taurus was loaded.
Do you have any knowledge of whether or not the defendant is allowed to carry a firearm?
Yes, the defendant was convicted in Ohio.
Objection, Your Honor, this hearsay.
Response.
Lack of personal knowledge.
Your Honor, I believe that he's testifying to information that he has obtained from law enforcement databases, just with respect to the circumstances of a possible arrest of the defendant. It's relevant as to the actions that he would subsequently take upon finding these firearms.
Then is it being used as substantive evidence or as to why he made the arrest?
Why he made the arrest, Your Honor.
So it's effect on the listener, not used for substantive. You may continue.
Thank you. Go on with your answer, thank you.
I'm sorry, could you repeat it?
Absolutely. Did you do any investigation as to whether or not Mr. Porter could have a firearm?
Yes, we searched in Lean and at the jail. They showed in his criminal history that it was previously convicted in Ohio on a weapons charge.
Your Honor, I move to admit People's marked Exhibit 1, which is a certified record from the state of Ohio showing that Jeremy Porter was convicted of carrying a concealed weapon on November 4th, 2014. I have shown this exhibit to the defense.
So I would make an objection to the admission of this particular exhibit. It does not contain a date of birth or a middle name. And so while it does reference a Jeremy Porter, I don't think there's sufficient evidence to establish that this record actually pertains to the Jeremy Porter sitting in this courtroom today.
Right, response?
Your Honor, the document speaks for itself. It's authenticated that this is the document pertaining to this defendant. When we requested this record with the defendant's name and date of birth, this is the record that was provided to us. I will seek to obtain additional documentation, but for now, I think that this document certainly assists the court in finding by probable cause that he's a convicted felon.
As authentication and foundation that it is what it purports to be, I believe it's met that level, which is a lower level, and certainly below probable cause, but it is a lower level. I'll allow it for purposes of preliminary examination.
Thank you,
So
Your Honor.
the exhibit's admitted.
believe that's all my questions for this witness, Your Honor. Thank you.
Cross-examination, Mr. Nichol.
Yes. Officer Stover. Prior to this incident, had you ever had any contact with Miss Duke or Mr. Porter?
I don't.
And you weren't present when anything that Ms. Duke was relaying was alleged to have occurred?
As far as the assault.
Yes, as far as the incident.
No.
You weren't there. Okay. So you don't know whether that statement Ms. Duke made to you was true or not? And did you or any other officer ever search Mr. Porter's vehicle?
I believe Officer Forbes and Officer Davis.
Okay. Do you know if anything was located, anything of relevance to this incident was located inside his vehicle?
I do not.
Okay. And stated that the two firearms, which was a black and silver Smith and Wesson and a black Taurus, were found inside the business at 925 Oakland?
That's correct.
Do you have any knowledge as to whether or not Mr. Porter was ever inside that business that day?
No, I don't.
And again, those firearms were found inside the business, not on Mr. Porter's person.
Correct.
I have no further questions.
Thank you. Any redirect?
No, Your Honor.
May this witness be excused?
Please.
From the defense, may this witness be excused?
Yes.
Without objection, you're excused from the witness stand, sir. And the people may call their next witness.
Thank you, Your Honor. Actually, Your Honor, I believe the people will rest at this point.
All right, any proofs, any further proofs from the defense?
No proofs from the defense at this time.
All right, motion for bind over.
Thank you, Your Honor. Today, we've heard the testimony from Lansing Police Officer Tyler Stover that on November 26, 2022, he had contact with a woman named Miss Duke. And she had called the police because her boyfriend of 6 years that she lives with and has 2 children in common with, Jeremy Porter, who Officer Stover identified for us as the defendant, had pointed a black and silver Smith and Wesson firearm at her. She stated that when this happened, she was scared of Mr. Porter, that she was possibly going to be shot. She gave officers information that he left in a maroon Jeep, and she gave a partial plate of 067D on that maroon Jeep. Shortly thereafter, Officer Stover did have contact with the defendant. The defendant was asleep inside of said maroon Jeep with the plate matching 067D, and he was parked at 925 East Oakland Avenue, which is his place of employment. He had the keys to that place of employment on his person, and that building was subsequently searched. They found the matching handgun that the victim described as the black and silver Smith and Wesson. They also found a second firearm that was loaded as well. According to People's Exhibit 1, Mr. Porter is a convicted felon of a specified felony, that being carrying concealed weapon, and is ineligible to possess a firearm. He committed that crime by having possession of the firearm and pointing it at 811 North Pennsylvania Avenue towards Miss Duke. He then took that firearm in with him into the car that he left in the maroon Jeep and placed it at the business in 925 East Oakland Avenue. So at some point, in order for the gun to get from location A to location B, that firearm was concealed in a automobile that he was driving or occupying, which would go to count 2, carrying concealed weapon. He did use that gun, a dangerous weapon, to assault Miss Duke, who he has an intimate domestic relationship with. So count 3 has been met by probable cause as well, and then the misdemeanor domestic violence would follow. I certainly think that all of the elements of the crimes have been met here by at least probable cause, and would ask that you bind this matter over to the circuit court.
Thank you. Response, defense?
Yes, Your Honor. With respect to Count one, I would ask the court not to bind over on count one. While a criminal record of a Jeremy Porter was submitted to the court today, I would still maintain and submit that that record does not contain a date of birth or a middle name. And so there, I think even to a probable cause standard, there's not sufficient evidence to suggest that record actually belongs to Mr. Porter, this Jeremy Porter, and therefore insufficient evidence that he is or was at the time of this alleged incident a convicted felon. With respect to carrying a concealed weapon, according to Officer Stover, what his testimony in court today was that Ms. Duke said that Mr. Porter entered the house, pointed a gun at her, then left. There was no testimony that he had the gun on him when he entered the vehicle or that he entered the vehicle with it. A gun, or two separate firearms were found inside of a business. As the officer testified, there's no evidence presented to this court today that Mr. Porter was ever inside that business. And so there's no evidence that either firearm found in the business are connected with this case or Mr. Porter or wherever on his person at any point. And therefore, I would argue that merely finding the guns is not sufficient evidence that Mr. Porter did carry a concealed weapon in a vehicle operated by him. These guns were not found in that vehicle. They have no evidence to suggest that actually suggest, even at a probable cause standard, that either of those firearms were ever in Mr. Porter's possession in a concealed manner or in that vehicle. With respect to the matter of felonious assault, I would leave that one to the court's discretion. I understand the testimony that was admitted under 27C. Understanding, of course, that it is the defense's position that that statute is not constitutional and its use is not valid. I understand the state of the law and what the court can do. And then as far as the domestic violence, that's a misdemeanor, which will simply follow.
Thank you. Any rebuttal?
I'll leave it to the court, Your Honor.
Right. So the standard of evidence at the preliminary examination that just occurred is probable cause. Probable cause is the second lowest criminal standard. The only lower standard than that is reasonable suspicion. District court has probable cause evidence to believe that the crime is committed as a felony and the identity of the person who committed the crime. We have location as 811 North Pennsylvania Avenue, City of Lansing, Ingham County. I believe that could be done for all three counts. The venue is the City of Lansing. The date is November 26, 2022. An identification was made by the witness, Tyler Stover, as the defendant was Jeremy Jerome Porter in regards to ID in court. As to so the counts that are so I kind of go backwards. In count three, there is the domestic assault hearsay statute, which would indicate that Mr. Stover indicated what Alicia Duke said to him in regards to felonious assault, that this defendant did make an assault upon with a dangerous weapon, a pistol, specifically a Smith & Wesson black and chrome or black and white Smith & Wesson firearm, without intending to commit the crime of murder and or inflict great bodily harm less than crime of murder, contrary to 750.82. The officer indicated that Miss Duke indicated that the firearm was pointed at her, that she was placed in fear, and that the firearm looked to be a Smith & Wesson as matched pursuant to what the indication of the officer. I believe that count three, probable cause, has been met in order to bind over on assault with a dangerous weapon. In regards to count one, felon in possession of a firearm at the probable cause standard, the only indication there's no the probable cause has been met as to the defendant being in possession of the firearm. So the prior conviction, which comes out of Franklin County, Ohio Criminal Division, indicates that a Jeremy J. Porter, and this is a Jeremy Jerome Porter identification purposes, the exhibit was admitted. It is an exhibit under seal from the Franklin County, Ohio Criminal Division Court, which would indicate that the defendant was found guilty of a felony in the 4th degree, which would place him ineligible in regards to the count. So I believe that at a lower standard, the probable cause has been met as to count one. I'll leave it to the circuit court to determine what the stand beyond a reasonable doubt whether this is sufficient. But at the probable cause level, did possess a firearm when ineligible to do so because he or she had been convicted of carrying concealed weapon. A specified felony and the requirements for gaining eligibility had not been met, contrary to the law of the state of Michigan. So I'll bind over on count one and count three. Counts two, I will also bind over on, but this is a little bit more problematic in regards to Mr. Porter having the gun, having the Smith & Wesson identified as a match gun, getting into a car with a gun, and then the car being found with Mr. Porter in it, at the establishment where he's employed, and that same gun being found in the business. There is probable cause evidence to believe that the defendant carried the concealed weapon, to wit the pistol, the Smith & Wesson, in the car when he left, and that's how it got to the second location at a probable cause standard. That there's some inferences there that I understand are being made, but I believe that suffices for the probable cause level. So did carry a dangerous weapon, a pistol, whether concealed or otherwise, in a vehicle occupied by Mr. Porter, and therefore contrary to the law of the state of Michigan. I bound over on counts 1, 2, and 3 as felony. Count 4, the domestic assault, will follow as a misdemeanor. So this time is done in district court, and the defendant's bound over as charged on the felony complaint. Anything else for the record, Ms. Smith?
Your Honor, I do want to address the status of the defendant at the time that this crime occurred. Mr. Porter has a documented, extremely long history of domestic violence with this victim, just from cases that have been issued, not just ones that have been reviewed. There's a 2019 case, a 2020 case, a 2021 case that are all misdemeanor domestic violence. And then in June of this year, the defendant was arraigned before Judge Simmons on a felony complaint of assault with intent to do great bodily harm, less than murder, assault with a dangerous weapon, domestic violence second offense, and the victim in all of these has been the same. That would be here, Miss Duke. I see that there's also been a new case that has been authorized by my office. It hasn't been sworn to yet at this court, which I will be handling as soon as we get off the record to see why that's not been done. But again, yet another domestic violence incident with Miss Duke. I have extreme fear for her at this time, given this ongoing domestic violence, the fact that he already had a pending DV with a no contact order at the time that this crime occurred. I'm not quite sure why he's not in custody on a bond violation. And I would ask that Your Honor remand at this point until we can get that settled.
Response?
Your Honor, as to the history of charged offenses that did not result in convictions, that's all information that the court would have been aware of at the time that his bond was set. So that's not new information. That's not changes in information. Whether or not he was on bond at the time that this case occurred, again, that's not new information. And Your Honor, respectfully, it does not appear that he actually was on bond at the time that this is alleged to have occurred. He had a prior case he was represented by Mr. Sartz of our office. That case was dismissed because Ms. Duke, as she did today, failed to appear for the preliminary exam. Mr. Porter and Ms. Duke's history, again, is something that certainly is information that within the bounds of the court. The court has not been presented with any allegations through police reports that I'm aware of that Mr. Porter has been violating the conditions of his bond in any way. And so I'd ask the court to leave his bond intact. I don't feel there's any basis right now to change or revoke his bond. I would ask that the bond be left in place. If new charges are filed, then he would have to be rearraigned, and the court can address whatever those allegations may or may not be at the time of that arraignment. But again, I don't know that any evidence is presented to suggest that one, there's any new information the court did not have at the time of its arraignment and setting of this bond, and two, that there's been any violations of that bond. And so I do not see any basis for which the court could revoke Mr. Porter's bond at this time.
Thank you. Is there a pending, there was an indication from the prosecutor's office that there was a pending assault GBH that happened previous to this event?
Yes, Your Honor.
Is that case active at this point?
Sorry, I was trying to see the timeline between the two systems, and it does appear that the felony strangulation occurred prior to this and was pending, but was dismissed prior to this occurring. So I retract my statement that he was on bond.
What was bond set on that case?
Bond set on that case was 15,000, 10%. But, and I understand Mr. Nichols' perspective of, you know, some of this information was known at the time. But Your Honor is well aware that at the time of an arraignment, prosecution usually does not appear and point out some of this information. So that's why I'm bringing it to the court's attention now. I'll note that the case that is authorized by my office and pending being sworn to here at the court has a offense date of September 24th, 2022. And again, I'll be talking to Detective McBride to get this sworn to today.
Response, Mr. Nichol?
So if the offense date of this other charge was September of this year, that also was prior to his placement on bond. I would just say that at this time, it appears that Mr. Porter is abiding by his bond conditions. And so I don't think there's any need to either increase his bond or to remand him. I would ask the court to leave his bond intact. I've had discussions with him about his bond conditions and the importance of following those, including the no contact order, which I know this court and the 30th Circuit Court take very serious. So I would ask that his bond remain as it stands.
All right, thank you. Yes.
Your Honor, understanding and I'm sorry for speaking without being asked.
You're fine.
Understanding that the defendant is on GPS tether and having clarified from my understanding the sequence of events and retracting my statement that he was on bond, I will leave it to the court's discretion, but remove my request for remand.
Okay. So right now, the defendant is on GPS tether with zone verification or victim verification. Let's see. I have 2,000 feet from Alicia Duke. Starts November 30th at Meyer Warehouse.
GPS tether does not include any zones. He's just on top.
All right, so let's add to that zones. Okay, so we'll add to the GPS tether device the residence of Alicia Duke. And what is her residence? So do you have that?
I do. I will email that information to JSG and to the court. I'll email her home address and her work address.
All right. So we can do that as a part of the bond condition, the no order. At this time, though, I do not believe, and this is I rarely override what another judge, but I think the 5,000 PR bond in a felony count is low. I just do, and that's how I see it, especially in regards to two weapons accounts, one assault, felonious assault, and a pending domestic. A PR bond is inappropriate as far as I see. So I'm going to set bond at, in regards to the bind over, I'm going to set bond at, it's still going to be $5,000, but it's going to be 10%. So bond is set as $5,000, 10%. And if defendant is able to make bond, you can add whatever address the prosecutor's office has in regards to Ms. Duke. Any further dates will be made available to you from your attorney Mr. Nichols in circuit court. Defendant's bound over on all counts.
Thank you, Your Honor. Nothing further. from
All right,
counsel.
thank you. That's all for the record and doc. Anything else for the record, Mr. Nichols?
Just to clarify, the Myers Warehouse comment, that's where Mr. Porter works.
Correct.
It's my understanding, and I guess Miss Smith can confirm, that isn't where Miss Duke works.
Correct.
Correct.
Okay.
So the no contact order will be in regards to Miss Duke's residence as part of the zone.
Yes, ma'am.
Will be emailing this to JGS.
I will email and I'll CC you on it.
I'm just updating the paper.
Absolutely. I'm gonna send that right now.
Thank you.
So bond is reset at 5,000, 10%.
Yeah, he's gonna take it.
And Ms. Smith, do you want your exhibit back?
Sure. Thank you so much, Your Honor.
So $500.
If he's gonna post
Yeah,
Mr.
that's it
Nichols,
for her.
he's gonna post to me to post to county, because he's gotta go to county to get the tether updated.
They need him to update the zones?
Usually they want him, is my understanding, Ms. Smith.
Pardon?
Will JGS want him to update the zones?
I don't know how that process works truthfully.
I
He's
thought
gonna
they
have
had
to
to
talk to.
reprogram something with the tether.
I don't know.
I think somebody in lockup should probably be able to answer that question.
Okay, I was gonna say, we've always sent them out there for any changes for tether. They've always had to go to county to post at that. point.
JSB's right there.
Yes.
Excuse me, Your Honor. I'm the one that worked at Myers Warehouse. I think the zone has already been set to her house at 2,000 feet.
All right, we'll just confirm that.
Okay.
All right. You should be able to go to work, sir. You just have to be out of 1,500 feet distance from her.
Yeah, no, she don't work there though. I think
Okay.
y'all might got that mistaken. I work there. That's
Right.
when the-
Right. I think we've got that covered, right?
Yeah.
the judge
And
let me
she's-
out so I
and-
could go to work.
Yes.
Yeah.
And the
You-
prosecutor's gonna
You make
confirm.
bond, you're good to go to work.
Okay.
Okay?
Is there anything? You're out, we can talk.
Ms. Smith, are you joining us this afternoon?
Indeed, Your Honor.
Okay. Mr. Nichols, do we have you on any pre-trials this afternoon?
I don't believe so.
All right.
You're welcome to join if you want to. I know there's nowhere you'd rather be than
Right,
Florida
but-
District Court on the Thursday before New Year's Eve.
You know, as fun as that sounds.
You want Ms.
If you
Robinson
agree
to
with
be here
that,
all
Mr.
alone?
Nichols, that says more about you than it should.
I mean, to be fair, his wife is here too, so he might as well.
That's true. That's true.
It's actually coming close to probably one of my last hearings in 54 in a while.
So
On the number ending in 1177, what's your name?
Jalen ready.
Can you repeat that, please?
Jalen ready.
All right, thank you.
Yeah. Hello?
And then oh, yep, I got you, Mr. Mitchell. The judge will call your case shortly, okay?
All right, thanks.
Cool. And on the iPhone, what's your name, sir?
Charles Simmons.
All right, thank you, Mr. Simmons.
You can have it.
Okay.
Huh? Oh, it started now?
In a minute.
Okay, hello?
Yeah, what's your name, sir?
Craig Paul Hamus.
All right, thank you.
Yep. You can hear a little bit. Oh, it's all the way up. Wi-Fi.
She had it all the time. They soon over so.
I don't know who any of these people are. Yeah.
Really sucks.
Okay.
So we got more than just one person in court. Oh, God.
In a courtroom or on home, you would still get finished right.
Probably.
I think it's crazy to do it.
It shouldn't be done.
Yeah, each person should be fucking practiced.
Mr. Simmons, I'm gonna place you in a breakout room with your public defender, okay?
Ready?
All right. So once Ms. Robinson enters the room, we'll place you in a breakout room with her.
All right. Oh, that's you up there at the bottom.
Mm-hmm.
You know, those.
And Judge, can I have a breakout room with Ms. English, please?
Rejoin your room one.
Yeah, my truck. Nobody put.
Don't be jealous.
Professor of Medicine and Chief of Gastroenterology at Eastern Virginia Medical School. Virginia, welcome back to Viewpoints. In this viewpoint, I wanted to base the question about, do we really need to do what we've done forever? Because that's the way we've done it forever. And in particular, I mean, clear liquid diet before colonoscopy. We know that colonoscopy is very predicate on the
All right, just, Mr. Polhamus, Mr. Mitchell, and Mr. Redding, you're all in the right place. We're just making sure we've got some files taken care of before we call your case, okay? But you are in the right place.
Okay, thank you.
I do have this. What's the green thing?
And I'm going to, so I'll swear you in now and then we'll start, okay? So raise your right hand. Do you solemnly swear or affirm that you'll make a true and understandable interpretation to the witness and these proceedings, and that you will accurately interpret the statements made by myself and these proceedings to the defendant, Mr. Jackson, to the best of your ability?
Yes, Your Honor.
And if you'll state your name and spell your last name for the record for the court recorder.
My name is Abdallah Mukoma, last name Mukoma.
All right, and so this is the time set for a probation violation hearing.
Kuja hapa ili ni mida kwamba nilipangwa kwani kwa kuvunja probation,
And will the appearances for the record?
kwamba ni wenye walikuja watuambie majina yao.
Good afternoon, Melanie Smith on behalf of the people.
Anaitwa Melanie Smith, yeye anashughulikia watu wenye walikosewa.
Aaron Robinson, Assistant Public Defender for Mr. Noel.
Kwamba Aaron Robertson na yeye anakusimamia wewe Mr. Noel.
All right, it's my understanding after that this is time set for a probation violation hearing. I've discussed the matter with both Ms. Smith and Ms. Robinson. And what we're going to do is, you can go ahead and.
Ndio anasema kwamba ni leo ilikuwa siku yani ya kusikia kwamba yani vile vinaendelea kwa hii hapa, lakini niliongea na Ms. Smith na Ms. Robinson hapa kwamba ni kuhusiana haya.
Is we are going to place this in abeyance. We're just going to see, I think there was some miscommunication concerning what you were supposed to do and in what manner you're supposed to do it.
Anasema kwamba ni saa hii tutaiweka kidogo hii kwa sababu ile ulikuwa unatakikana ufanye, yani bado hujapata vizuri.
And I don't think that's the proper foundation for having a violation of probation when you were uncertain of the guidelines.
Anasema kwamba ni kwa vile yani mipango ile wao walikuwa wanatakikana wapange, ni kama vile walipata mtu mwingine mpya, kwamba ni sahihi wataiangalia kwanza utaendelea na vingine.
So we're going to hold this. So we're going to continue probation. The in probation date is February 28, 2023.
Kwamba ni kwa kuja hapo ni kama hivi mwezi wa pili tarehe wa 2022 February.
That's February 28th of 2023.
Okay, mwezi wa pili tarehe 28 mwaka huu unakuja, ndio kwamba tutakuja kuongea hizo habari.
And we're just going to continue probation.
Toka saa hii tutakuwa tunaendelea kwa kupima.
And you'll be under the auspices of a new probation officer because this one has left.
Kwamba ni hao sasa saa hii wewe unafuata neno ile probation anakutuma ofisa.
So we want to make sure that you understand the guidelines for your probation as directed by the probation office.
Anataka ujue kwamba ni mipango ile ya probation anakupangia na ufuate hiyo. Thank you.
Okay. Ms. Smith, anything for the record on this file?
No, Your Honor.
Kitu yoyote unataka kuongeza kwa hili record? Akasema hapana.
And then Ms. Robinson, you've had the opportunity to speak with your client.
Ms. Robinson, ulikuwa na chance kwamba ya kuongea na mtu wako.
Did you want to make a record in this regard?
No, Your Honor.
Kitu chochote hapa ndani? Anasema hapana.
No, Your Honor, I think we've covered it.
Anasema tumefunika kila kitu.
So what's our next step? Is he to go back to probation to make sure that he understands the guidelines concerning his responsibilities there?
Anasema kwamba ni saa hii wewe jukumu yako ni kwenda kwa probation akuonyeshe njia vile inaenda.
Yeah. So nilikuwa huko nikauliza.
And today even I was there in the office.
Wauliza jinsi probation yangu itaendelea.
And how my probation is going to get going.
Okay.
And they will text me to know when I'm going to go and do the testing. Also, they will text me. I ask them the testing center.
All right. So you don't have any questions concerning your probation right now, sir?
Saa hii huna swali yoyote kuhusiana haya.
Leo sina swali, lakini swali niliuliza, sijui niliitwa kama tarehe mwezi wa kwanza tarehe 12. Sijui kama hiyo inaweza ifuatilia.
Yeah, for today I do not have question, but on the 12th, January 12th, I have an appointment with the probation office. So I don't know if that involves here too.
No, it won't, but make sure you make that appointment and then make sure that if you need an interpreter for that day, that somebody's available.
Nasema kwamba hakikisha umefika kwa hiyo rendezvous tarehe 12. Na pia kama unataka mtu wa kumtafsirisha tena atakuwa hapo.
Okay, nitaji kwa sababu itakuwa ni saa 3.
Yes, I need it and it's 9:30 the appointment.
All right. Anything else for the record, docket 22015007 Ms. Smith.
No, Your Honor.
Kuna kitu chochote tunataka tuongeza? Ms. Smith anasema hapana.
Anything, Ms. Robinson?
No, Your Honor, thank you.
Na
All right.
mwanasheria yako Mr. Robinson kwamba kama kuna kitu chochote anasema hapana.
All right, Mr. Jackson, we're gonna act like this was just a bump in the road, and we're gonna continue probation and see how you continue.
Sema
Okay,
kwamba
sir?
tutakuwa kwamba iko kwa njia hivi, sasa tutaendelea kufuata tu probation vile inaendelea. Thank you.
All right, that's all for the record in 2201-507.
Imeisha kwa rais wa mkondo sahihi.
All right, thank you for your help today.
Thank you.
Hello? Hello?
Mr. Redding.
Mr. Redding, we're still waiting on we're still waiting for some files before yours, okay?
Yes, sir, my bad.
Mr. Redding, I'm sorry, I can't hear you.
I said yes, sir. I'm sorry about that.
I still don't know what you said.
Yeah, I had said yes, sir. I'm sorry about that.
Sir, I'm sorry about that.
Okay. All right. We're just waiting. We're waiting. We have a couple lawyers to join us. They're in other courtrooms, and then we're going to get started. Okay.
Yes, sir.
So, Miss Alvarez, you are in the right courtroom. All right. You'll have to unmute yourself. All right. And we've got about 4 or 5 files in front of you, and then we'll call your case. All right.
Thank you.
You
All
can
right.
come on up, Mr. Powell.
We're on the record in docket 21-00334. That is people of the state of Michigan versus Jasmoni Powell. Will the parties please introduce themselves for the record?
Good afternoon, Your Honor. Melanie Smith, Assistant Prosecuting Attorney on behalf of the people.
Aaron Robinson, Assistant Public Defender for Mr. Powell.
And sir, you are Jasmoni Powell?
Yes, I'm.
All right. Ms. Smith, this is the time set for a pretrial in the matter. How are we proceeding?
Your Honor, I would ask the court to dismiss this matter. I have just seen proof, verification that Mr. Powell did rectify the licensing issue. He paid the fee to have the license reinstated, and he no longer owns the animal. So dismissal would be in the interest of justice.
And that's your understanding, Ms. Robinson?
It is, and we have no objection.
All right. So, Mr. Powell, the people are moving to dismiss this case without prejudice, which means they could reissue it some other date if they chose to. But it sounds to me like for all intents purposes, the case is dismissed today, okay? All right. That's all for the record in docket 21-00334.
Thank you, Your Honor.
And that's a ticket, isn't it? Yes. We don't have to worry about it.
Everyone else on the
This is
document.
yours.
Okay. What's up with Miss English?
So Ms. English says that she only the dogs left. Apparently they were puppies.
Okay.
And so like she sold them all.
Okay.
So she's gonna try to get proof of like the ones that she sold, receipts and checks and stuff, and then get the license for the one dog that she.
Honestly, she and just look at the home to see that she's only got the one. And then if she can just show me that she's got the license for the one that she's got, that's fine.
Okay, cool. So like 30, 40
30 days.
whatever.
40 days. Right, so we're on the record. Miss English, I'll have you unmute. All right, thank you. We're on the record in docket 22-02951, 52, 53, 54, 55, 56, 57, 58, and 59. As people of the state of Michigan versus Heidi English. Will the parties please introduce themselves for the record?
Good afternoon, Your Honor. Melanie Smith, Assistant Prosecuting Attorney on behalf of the people.
Aaron Robinson, Assistant Public Defender for Miss English.
And ma'am, you are Heidi English?
Yes, Your Honor.
And you can hear me all right, Miss English?
Yes, I can.
All right, thank you. This time set for pretrial in the matter. Ms. Smith, how are we proceeding?
Thank you, Your Honor. Today, we're going to ask the court for a brief adjournment, anywhere from 4 to 6 weeks on the court's schedule. I'm going to call Ingham County Animal Control and have them do a follow-up visit to the home. It's the defendant's statement that she no longer has a majority of these animals. They were puppies that were either sold or given away. So I'd like for Ingham County Animal Control to verify for me the amount of dogs that she has. And then as long as she can provide licenses for any of the dogs that she still has, at that reset date, we would dismiss.
All right, is that your understanding, Ms. Robinson?
It is, Your Honor.
So we'll look for a date 3 to 6 out.
That'd be great, Your Honor.
How about February 7th at 9:30?
February 7th.
At 9:30?
At 9:30 for the second pretrial for compliance purposes. Does that date suffice, Ms. Smith?
Yes, Your Honor.
Ms. Robinson?
It does. Thank you.
All right, Ms. English, we'll adjourn this for second pretrial for compliance purposes to February 7th at 9:30. You're to keep in contact with your attorney, Ms. Robinson, in order if you have any questions. All right, ma'am?
Yes, sir.
All right. Anything else for the record? Docket 22-02959, Ms. Smith?
No, Your Honor.
Anything, Ms. Robinson?
No, Your Honor, thank you.
All right. Ms. English, so you'll be back. We're meeting in compliance on that date. On that February 7th date. You're free to leave the Zoom courtroom. Thank you for your appearance.
Thank you, Your Honor.
All right. Yeah, I'm gonna write in those afterwards.
I gotta get them all.
Okay. So while you're doing that, I might write these files.
Next PE date on the felony case for Reading. It's not.
Isn't that the one that he had a student with brother and that we were?
Yes.
Okay.
I'm like, why can't I find this?
Yeah.
So we're on the record in docket 22-03150. It's people of the state of Michigan versus Charles Simmons. Will the parties please introduce themselves for the record?
Afternoon, Your Honor. Melanie Smith, Assistant Prosecuting Attorney on behalf of the people.
Erin Robinson, Assistant Public Defender for Mr. Simmons.
And sir, if you unmute yourself, are you Charles Simmons? And you'll have to unmute yourself.
Mr. Simmons, you have to click the microphone at the bottom of the screen. Touch the phone and then touch the microphone at the bottom of the screen. It will unmute you.
There you go.
There you go.
Hello?
All right, there you are, sir. You are Charles Simmons, sir?
Yes.
All right. This is the time set for a pretrial in the matter. Ms. Smith, how are we proceeding?
Your Honor, today we would be asking the court for a 2-week adjournment This is a dog at large case, but there were no animals hurt. There was no property damage. So really what my priority is just ensuring that this dog is properly licensed. So we would ask for a 2-week adjournment. Mr. Simmons will provide proof of licensure, and upon that proof, we will dismiss.
Ms. Robinson, is that your understanding?
It is, Your Honor. Thank you.
All right. So any date 2 weeks out?
January 17th
January 17th
at 9:30.
at 9:30.
That's just the second pre-trial.
Right. So, Mr. Simmons, we've set this for January 17th at 9:30 for compliance purposes. Please keep in contact with your attorney, Aaron Robinson, if you have any questions.
Okay.
And that's all. That's all for the record. Docket 2203-150. Ms. Smith, anything else?
No, Your Honor. Thank
Ms.
you.
Robinson?
No, we're all set. Thank you.
All right, Mr. Simmons, you're free to leave the Zoom courtroom. Thank you for your appearance today.
Thank you.
Who's next, Ms. Smith?
Jalen Redding.
And he's on a phone. Oh,
Yeah,
there he is. Now he's on video.
Now he's on.
He was not on video beforehand.
All right, Mr. Redding, you can unmute yourself. And we're
Yes,
on
sir.
the record in docket 2203-485. That is People of the State of Michigan versus Jalen Redding. Will the parties please introduce themselves for the record?
Good afternoon, Your Honor. Melanie Smith, Assistant Prosecuting Attorney on behalf of the people.
Aaron Robinson, Assistant Public Defender for Mr. Redding.
And sir, you are Jalen Redding?
Yes, sir. Jalen Redding.
Okay, and you can hear me all right, Mr. Redding?
Yes, sir.
All right, thank you. Ms. Smith, this is a time set for a pretrial in the matter. How are we proceeding today?
Your Honor, Mr. Redding also has a felony file, assault with intent to do great bodily harm, less than murder, and domestic violence, regarding the same victim as the misdemeanor case that's set today. We do have a global resolution that will resolve both of those cases. So we would just request that we get the earliest possible date for a plea from this court so that Mr. Redding can appear in person, which will allow us to effectuate the plea much easier than here today on Zoom.
Okay, so set it for guilty plea date?
Yes, Your Honor.
Is that your understanding, Ms. Robinson?
It is. Thank you.
All right, so we'll set it for, does it matter how many days out that is?
We prefer sooner rather than later because
Okay.
we just don't want that hanging over our
So
head. Yeah.
a guilty plea date.
I can do it Tuesday,
That's fine.
Okay,
3rd.
so January 3rd, 2023 at,
Oh, let's throw him in at 10:30.
that scares
I
me,
have a
10:30. So, Mr. Redding, did you have a question for me?
yes, sir. I was going to ask, can it be on Zoom? Because right now I don't have no transportation.
It's got to be live because we're going to be wrapping up several files. And so in order to make sure that you understand the nature of 2 domestic assaults and another felony file, we want to make sure to have you in person to waive all your rights. Okay, sir?
Yeah.
All right. So it's set for January 3rd, 2023 at 10:30. Anything else for the record, Ms. Smith?
Your Honor, just for ease of being able to clarify everything on Tuesday, the felony file that I indicated is pending, he's actually in warrant status for right now. So if that felony file can get pulled to be available on Tuesday, we would just dismiss that prior to him even being arraigned on it.
Okay, and what's the number on that file? Do you have a?
I have our internal number. Let me get you the court number. Oh, you got it? Thank you.
Just 1 second.
Yeah, we'll just put all the files together then.
The felony is 22-03-555. Ms. Smith, are you requesting that warrant be quashed today?
No, at the time of the guilty plea, please.
Okay.
And then there's a separate DV file that'll also be a part of this, right?
Nope, this DV file, and then
And
the
the
other
felony.
one is the felony with a DV.
Perfect. All right, so if you have any questions, keep in contact with your attorney, Ms. Robinson. Ms. Redding, you had another question?
Yes, just one more regarding the warrant. Do I have to turn myself in or just wait until Tuesday?
Just wait. That'll all be taken care of on January 3rd. So you don't have to turn yourself in.
Okay, thank you.
Is there some way we can put anything on that?
If you just pull the file.
Can we put a hold on it, or I don't know what that means. Your device is into a problem and needs to restart. Well, that's our problem. So yeah. Wendy did that to her
Do we know
computer.
why the,
Only yours did that, by the way.
I know, but we're not recording, so.
Yeah.
Do we know why the felony file is out there? Because my thing just disappeared.
Do we know why what?
What's the chart? Is it a new felony? Is it a failed to appear felony?
No, it's a newly issued felony. So it's just a initial warrant.
The two choices with this court, unfortunately, are either you can take the warrant out now, or the warrant stays, and if he has contact, he will be taken into custody.
All right, let's take the warrant out and set it for a probable cause conference for January 3rd. We do that?
Yeah, why not?
I know we're kind of making some legal fiction.
Yeah,
here,
but
because
if
he wouldn't have
that
been
just so
arraigned,
that
but-
he doesn't get arraigned on a
Right.
warrant over the weekend.
Right.
Yeah.
Yeah, that was why we wanted it quickly, was so
And
that.
I'm recording on Zoom.
Okay, that's fantastic.
Yeah.
I'm glad that we're recording.
Something's got to be recorded.
Yes, I would say go get the warranted file that thing possibly. And we'll have Judge write in the file, we'll have the warrant taken out.
Okay. So, Mr. Redding, what we'll do is make sure you show up on January 3rd. We're gonna make sure that the warrant on the outstanding felony is pulled, so you're not picked up on it over the weekend, up until your January 3rd date. Of course, if you miss that date, everything will be reissued, so you will be picked up on it. But if you're here at 10:30, we should be able to take care of this file and that felony file on the January 3rd, that Tuesday. Okay, sir?
Yes, sir.
All right. So that's all for the record in docket 22-03485. Mr. Redding, you're free to leave the Zoom courtroom. Thank you. We'll see you on the 3rd, okay?
Yes, sir. Thank you.
Okay. I'm gonna put that aside. All right, we have a few cases left, but we're gonna just make sure the computer system's up, and then I'll start calling cases again.
Craig Polhamus.
All right, we're on the record in docket 22-02622. That is People of the State of Michigan versus Craig E. Polhamus. Will the parties please introduce themselves for the record?
Good afternoon, Your Honor. Melanie Smith, Assistant Prosecuting Attorney on behalf of the people.
Aaron Robinson, Assistant Public Defender for Mr. Polhamus.
And sir, you are Craig Polhamus?
Yes, sir.
All right, and you can hear me all right, Mr. Polhamus?
Yes, I can.
All right, this is the time set for a pretrial in the matter. Ms. Smith, how are we proceeding today?
Your Honor, I've spoken with Ms. Sutter, who is the actual appointed attorney on this file. We appreciate Ms. Robinson standing in. There is a 1-for-1 offer on this file that the defendant intends to take. There's just a slight, I wouldn't even call it an issue, but just something that we're dealing with. He's also on probation in Eaton County. We would like to consolidate his Eaton County probation here in Ingham County. So Ms. Sutter is reaching out to see if they can transfer that probation here. So we would just request maybe a 2 or 3 week adjournment, and we can just set it for a plea, just so that she can get that side of things handled. I did want to make a note of the fact that Mr. Polhamus is currently living at the House of Commons and already working on his sobriety, which we're very proud and happy for him for that. And this plea will just be one more step in the right direction.
Okay. So second pretrial date is set for
17th of January.
17th of January
17th of January.
at 9:30. All right, so Mr. Polhamus, we've set your date for plea date on January 17th at 9:30. If you have any questions, please keep in contact with your attorney, Aaron Robinson from the Public Defender's Office. All right, sir?
Okay.
All right.
Thank you.
Anything else on the file in 22-02622? Ms. Smith?
No, Your Honor, thank you.
Anything, Ms. Robinson?
No, Your Honor, thank you.
All right, we'll see you back here on the 17th of January. You're all set, Mr. Polhamus.
Thank you, Your Honor.
You're welcome.
What? Oh, yeah.
Tyrese Mitchell, when the court is ready.
Mitchell. So we're on the record in docket 22-03336, People of the State of Michigan versus Tyrese L. Mitchell. Will the parties please introduce themselves for the record?
Good afternoon, Your Honor. Melanie Smith, Assistant Prosecuting Attorney on behalf of the people.
Aaron Robinson, Assistant Public Defender for Mr. Mitchell.
And sir, you'll have to unmute yourself. You are Tyrese Mitchell?
Yes, sir.
All right, thank you. And you can hear me all right, Mr. Mitchell?
Yes, sir.
All right. This is the time set for a pretrial in the matter. Ms. Smith, how are we proceeding?
Your Honor, we'd like to set this matter for a final pretrial date.
And we'll set for final jury trial for the same. So final pretrial date?
17th at 8:30.
January 17th at 8:30, and then jury trial?
February 7th at 8.
February 7th at 8. All right, so Mr. Mitchell, we've set this for final pretrial on January 17th at 8:30. We've set it for jury trial on February 7th at 8 o'clock. Please keep in contact with your attorney, Aaron Robinson, if you have any questions. Anything else on 22-03336, Ms. Smith?
No, Your Honor.
Anything, Ms. Robinson?
Your Honor, briefly, I don't know if this is part of the file or not, but he does have children in common with the alleged victim. And so we were just going to be asking if a third party could perhaps arrange any sort of visitation so that he can see his children. He just really hasn't had a way since this case has been going on to do that.
So how old are his children?
Mr. Mitchell, how old are your kids?
I only have one. He's 3. He'll be 4 in February.
All right, Ms. Smith, any comment on that?
Your Honor, I will make a call to Ms. Smith when we get off the record here today and ask her for a recommendation of a neutral third party that can help assist with drop off and pick up of the child. I think that we would not have any objection to that as long as we can find a third party that's agreeable by both parties.
All right. What I'm gonna do is I'm gonna leave it as is and wait to hear from an email that would probably go to you, Ms. Robinson, to
Sure.
send to us, and then we'll readjust a third party visitation order in regards to this. That's more for your protection, Mr. Mitchell, just so everybody knows that there's a third party where you're able to see the child, and it's in writing, so you don't get picked up on some, no contact order violation. We should be able to do that in the next week or so. Okay, sir?
Understood. Thank you.
All right, thank you.
Can I get those court dates one more time real quick, please?
You sure can. The final pretrial is January 17th at 8:30.
Okay.
And the jury trial date is February 7th at 8.
Thank you very much.
All right, you're all set, Mr. Mitchell. Thank you for your appearance today.
You're welcome. Thank you.
And the last one should be Alvarez.
So we're on the record in 22-03492. That is Toriana Alvarez, people of the state of Michigan versus Toriana Alvarez. Will the parties please introduce themselves for the record?
Good afternoon, Your Honor. Melanie Smith, Assistant Prosecuting Attorney on behalf of the people.
Aaron Robinson, Assistant Public Defender for Ms. Alvarez.
And ma'am, you are Toriana Alvarez?
Yes, sir.
And you can hear me all right, ma'am?
Yes.
All right. This time set for a pretrial in the matter. Ms. Smith, how are we proceeding today?
Your Honor, today we'd like to obtain a final pretrial and jury trial dates from the court, please.
All right, final pretrial date?
January 17th at 8:30.
And so that's final pretrial will be January 17th at 8:30. And the jury trial date?
February 7th at 8.
February 7th at 8 o'clock. So, Ms. Alvarez, your final pretrial is January 17th at 8:30, and your jury trial is set for February 7th at 8 o'clock. If you have any questions, keep in contact with your attorney, Aaron Robinson, from the Public Defender's Office. Okay, ma'am?
Yes, sir.
All right. Anything else for the record, docket 22-03492? Ms. Smith?
No, Your Honor, thank you.
Anything for the record of Ms. Robinson?
Actually, just briefly, Ms. Alvarez, is your phone number still the phone number ending in 8724?
No, it's 517-894-7420.
Okay, thank you.
Okay.
Anything else, Ms. Robinson?
Nope, that's it.
All right, thank you. That's all for the record. We'll see you on January 17th at 8:30. That's all for the record, Ms. Alvarez.
Okay, thank you.
Thank you. That was pretty easy once everything got going, huh?
Yeah.
All right, Ms. Smith, well, it's been a pleasure to have you here.
Thank you. It was a fun day, Everyone have a great new year.
You too.
You too. Oh, like I said, I'm gonna be pulling carpet, so it's gonna be
Yeah, that sounds like fun.
very exciting.
Well, I'm gonna be here, so hey.
Yeah, I won't slip. Mine's bad. Yours is
So who's on call? Who's got the on call for the judges?
It's Magistrate Faulkner.
Oh, that's right. Well, here's to a uneventful New Year's.
Yes.